Assignment.
Just wait for a couple of minutes.
Shall we wait for a couple of minutes or we will start? Okay. Good morning, everyone. I hope the participants from online, you can see the presentation. I hope, right? It is visible.
Good morning, sir.
Good morning. Good morning. Today, our topic is uh, not only arbitration and arbitration, labor tribunal, arbitration, industrial court, and labor tribunal. First, we will touch upon the arbitration part, and then industrial court, and finally, even though the title is arbitration, this is not only arbitration, uh, but also industrial court and labor tribunal. In my, the first lecture, I discussed, in summary, the first day, the settlement of industrial dispute. There are main three ways of settling industrial dispute. One is conciliation, or collective agreement, through collective agreement. And then conciliation. Conciliation is the most important part. All, out of industrial, total number of industrial disputes, more than 90% are present cases are settled through conciliation. And then after conciliation, we are supposed to discuss arbitration, industrial court, and finally the labor tribunal. Right? Labor tribunal, the next one. Today, we are going to deal with the arbitration, industrial court, and arbitration, industrial court, and yes, labor tribunal. Next week, we will be having agreement and collective agreement. Do you have any topic in relation to ILO convention? No. ILO conventions?
Yeah, under what you took.
Yes, yes. Supervisory body and all this talk, right? Because I love to lecture on ILO convention. That is my most I'm in the competent area, except what you call this industrial dispute and termination. I don't like to lecturing in lecturing what you call this EPA, PDA activity, but I'm competent. But I love to teach settlement of industrial dispute, ILO conventions, and termination of employment. Those are important areas as far as the industry relation is concerned. Terms and conditions also important. Okay, well, let me, whether it can be not only arbitration, just let me ask someone, because I have to some adjustment here, otherwise. I just wait for 2-3 minutes to ask someone. Just to make the correction and the reading. बड़ी एडजस्टमेंट करेगा फोटो में मिनिमाइज करेगा ना again make arbitration mitra ने बताओ क्या लग Arbitration and industrial court. No. And arbitration and LT labor tribunal and LT capital L. But thank you. Okay, well, today we are going to discuss arbitration. Arbitration includes industrial court as well. Right? So, and the labor tribunal. If you have any question, you are, feel free to stop me and raise your question or any other clarification. The arbitration, if you remember, at the beginning, in my first lecture, I don't know whether this is visible for them, the board, IDA, Industrial Dispute Act, right? Settlement of industrial dispute, right? Commissioner, minister, and LT. Commissioner, agreement, right? Conciliation, and voluntary arbitration. Minister, arbitration, compulsory arbitration, and industrial court. This one is this is the the summary of the settlement of industrial dispute under the Industrial Dispute Act. So this is the summary. Commissioner through agreements, collective agreements, and conciliation and voluntary arbitration. Minister, compulsory arbitration, industrial court. Finally, LT, labor tribunal. This is the summary of the settlement of entire the mechanism with regard to settlement of industrial dispute. Right. Today, in last week, I discussed the agreement and the conciliation. Right. Today, arbitration, there are two types of arbitration: voluntary arbitration by the commissioner and compulsory arbitration. The industrial court also arbitration, but it's a separate one, but coming under the arbitration. So, and the labor tribunal. Today, we are going to discuss all the remaining part with regard to the settlement of industrial dispute. Is it clear to you? Anthony Pereira, is it clear? Well, so if you want to, first one, the commissioner, minister, and LT, right? Commissioner under section 3, right? Agreement, conciliation, and the voluntary arbitration. And the minister, compulsory arbitration, industrial court. Last one, labor tribunal. Well, the coverage. What I'm going to cover today? This one, another one is there, right? We have to add number 5 because introduction, powers of the minister to refer industrial dispute for arbitration, process of arbitration and principles of justice and equity, repudiation of arbitration award and its effect, right? And also there are a couple of things you need to add: industrial court, right? Industrial court and labor tribunal, and if you do, the under the coverage, there should be, number 1, introduction, number 2, powers of the minister to refer industrial dispute for arbitration, process of arbitration and principles of justice and equity, repudiation of arbitration award and its effect, and then number 5, industrial court, and number 6, labor tribunal and the appeal procedure. Labor tribunal and appeal procedure. Yeah, it will be covered, right? Not only minister, powers of the you can adjust it, powers of the commissioner and minister. Number 2, under the powers of the commissioner and minister to refer, because under the commissioner there is nothing much, because if both parties agrees, the commissioner can refer dispute for settlement. Right. Well, and the next one, benefits for, what are the benefits? Right? Being more advantageous than judicial procedure. What is the judicial procedure? LT. LT is the judicial procedure, right? And relatively low cost method. Remember, you have to understand one thing. No one, once labor department receives industrial dispute, the minister or the commissioner cannot refer such disputes for arbitration at the first instance. Cannot jump to arbitration. You need to understand the procedure. Once the industrial disputes are received by the labor department, first labor authority should look at whether there is an internal arrangement like agreement or collective agreement, and such agreements have provisions to settle industrial dispute at the workplace. If so, commissioner may ask both parties, hey, look, you have the collective agreement or whatever the agreement between trade union or workers and the employer. That agreement contains, if that agreement contains provisions how to settle industrial dispute within the organization without going for labor authority, then the commissioner may, if commissioner realize that if such agreements are there, then the commissioner may ask, why don't you try, right? Because you have an agreement, it contains the provisions how to settle industrial dispute amicably, right? By discussion, having discussed with the parties and the workplace. Why don't you try? That is what we mean by agreement. Settlement through agreement. Basically, the collective agreement. All collective agreements have provisions to settle industrial dispute amicably at the workplace without interference of the labor authority. So commissioner may ask, sometimes may not. Then conciliation, that is the most important part. What labor authority does, collecting EPA, PDA, looking at whether, the terms and conditions, but majority, main focus, one main area is the industrial dispute, settlement of industrial dispute through conciliation. That's what we discussed last week. If conciliation fails, then only industrial dispute can be referred for arbitration. If conciliation fails, otherwise, without conciliation, matter cannot be referred for arbitration. Yes, it can be done if there is major strike or major, something like, very significant strike and it affects to the significantly affects to the entire country. Then just have, the one discussion with the commissioner, right? With both parties. If they are not going to, settle it amicably, then suddenly it can be, put into arbitration. But in principle, if a matter could be referred for arbitration if conciliation fails. Conciliation fails. Remember, out of total number of industrial disputes received by the labor department, less than 10%, cases are referred for arbitration, both voluntary and compulsory. 90% or more than 90% disputes are settled through conciliation. That is the duty of the labor department. Right? I hope you understand. So, relatively low cost method, and also it is better to be able to inquire about the problem and make a decision when the stakeholders have special expertise regarding industrial relations. If you go to something like, the labor tribunal, it's quasi-judicial. Labor tribunal's judicial process is further. But here, arbitration also is a settlement. Arbitrator should award just, the award should be based on just and equity principle. And since laws such as the Evidence Act, Civil Procedure Code, and the Interpretation Acts are not relevant, arbitration වලට එනකොට when you go for arbitration, at the, the magistrate court LT වල වගේ, Evidence Act, Civil Procedure Code, those are invalid. Here, what is important is the reference. The arbitrator is not supposed to, refer Civil Procedure Code, Evidence Code, Interpretation Act. Arbitrator is not supposed to touch upon those the legal provisions. But arbitrator look at the Industrial Dispute Act. What is the power stipulated in the Industrial Dispute Act under the arbitration? And arbitrator must focus the reference. Reference means what is the dispute? Right? Who interpret it? The commissioner. Commissioner, once conciliation fails, right, the matter has to be referred for voluntary or compulsory arbitration. Then the commissioner has to prepare a document. The document very important. It's a thick document, but very important part is the reference. Reference means what is the dispute? The arbitrator should focus that reference, only that reference. But he can gather, a lot of information in relation to the reference made by the commission. Okay, right. So The ways of arbitration. There are two ways of arbitration. Voluntary arbitration, section 31D, under the commission, referring to an arbitrator or labor tribunal. Why labor tribunal? Normally, under the the arbitration, no cases, never referred for labor tribunal. But at the beginning 1950s, when labor tribunal was established under the Industrial Dispute Act, at that time it was not a court. The administrator who had conversion, the knowledge about the act, they were appointed as LT president, not lawyers, not judges. The person, the administrator, basically, their role was to inquire into the matter and grant award based on just and equity principle. But now later, it has become a court now, right? And that is why, at that time, president of the LT was just, an administrator who had very good knowledge. That is why at that time, even LT president can be appointed as an arbitrator, not as LT president. Okay, that is why, it says arbitrator or labor tribunal. Labor tribunal means labor tribunal president is appointed as an arbitrator to look into this matter. ඒ කාලේ මේක ordinary සාමාන්‍ය මිනිහට යන්න පුළුවන් තැන. මේ මිනිස්සුන්ට just and equity principle එක මත ඉක්මනින් තීන්දුවක් ගන්න පුළුවන් විදියට. දැන් මේක කෝට් එකක් වෙලා. උසාවියක් කරා. ඒකයි ඒ කාලේ labor tribunal එකට president administrator, not a judge. Yeah, the person could be appointed as an arbitrator. That is why labor tribunal is there. Don't misunderstand that. This doesn't mean that the case is referred for arbitration. Sorry, labor tribunal. No. Labor tribunal president can be appointed as an arbitrator and ask him or her to look into this matter and grant award, not order, award based on just and equity principle. Right? So, compulsory arbitration, section 4.1, by the way, is referring to an arbitrator, right? Referring to labor tribunal. By whom? This one, by the voluntary arbitration by the commission, right? And compulsory arbitration by the minister. What is the difference between voluntary arbitration and the compulsory arbitration? In my first lecture, I discussed these things. What is the difference? Referring to LT under section 4.2 is also compulsory arbitration. LT means, remember, I'm repeatedly saying, the matter is not referred for a labor tribunal. Labor tribunal president can be appointed as an arbitrator. I'm repeating. But nowadays, no case, because they are now additional magistrate. So they are not accepting to work as an arbitrator. We are Paulus that arbitrator එකක් විසඳන්නේ නැහැ 25,000 ගොල්ලෝ දැන්. කරන්නේ never nowadays. But in 1950, at the time this act was enacted, at that time, LT was just like arbitration. Labor tribunal. Okay? The labor tribunal head or the president was just an administrator who had good knowledge about the labor industrial dispute act. So therefore, at that time, it was possible to refer industrial dispute to LT president, appointing him or her as an arbitrator and ask to give just an equity award. But LT,
I think now it will be president. They don't appoint that to be.
yeah, but because they are appointed by the Judicial Service Council. Previously, it's under the Ministry of Labor. And long back ago. But now, because the long story, now LT has become quasi-judicial. No cases. Remember, no cases, industrial disputes are referred for LT president now. Previous, it is there in the act. That is why I'm, putting it here. But no cases are referred for LT now. LT is separate body now. Separate body. If your employment is terminated, then you can go to directly labor tribunal. Okay. Arbitration, even though Act says nowadays, in practice, previously it was, now no cases are referred for LT, appointing the LT president as arbitrator. They won't accept it. They won't accept. On termination. If correctness of gratitude. And with regard to termination, you can go to the labor department as well, right? If the workplace total number of employment is more than 50, no more than 55. Well, right. So, referring to LT under section 4.2, LT means appointing LT president as an arbitrator, not LT. Well, what is the difference between voluntary arbitration and compulsory arbitration? Before referring for arbitration, the labor authority who is handling the dispute has to send a report to the Commissioner General. The person, the inquiring officer, has taken every step to settle. What are the steps that he has taken, right? And however, fail due to disagreement between, the report has to be submitted to the Commissioner General. Then the Commissioner General ask both parties, Commissioner General or inquiring officer, whether now we are at a deadlock situation. So, I mean, you are not coming to an amicable solution, both parties. So, would you allow me to refer this matter for arbitration? If parties, right, to the dispute agree, then Commissioner can refer that matter to an arbitrator for settlement. That is what we mean by voluntary. Voluntary means when Commissioner asks, conciliation failed, Commissioner asks, would you allow me to refer this matter for arbitration? If parties give consent, that is the voluntary. Parties give consent. Yes, okay, we agree. Then matter is referred to arbitration. That is called voluntary arbitration. Voluntary arbitration means matter industrial dispute is referred to an arbitration with the consent of the parties. No. Arbitrator is separate thing, right? I mean, the document has to be prepared for arbitration, not the report, right? Commissioner is not supposed to submit a report for an arbitrator, right? matter is referred for arbitrator, appointment. Arbitrator is appointed. Appointment letters are there, right? And then the commissioner, very clearly specify the unambiguous reference. What is the dispute? That is more important. There are a large number of, document in the sense letters, appointing them, right, gazetting. There are, procedures to be followed, right? What is, important for the arbitrator is the reference. Reference means specifically ආරවුල කුමක්ද යන වගේ කෙටියෙන් කියලා පැන එකක්. That is the most important one for an arbitrator. It gives an arbitrator, some kind of picture. Then arbitrator, right, call both parties because the documents are sent to the both parties. Arbitrator has been appointed, and you will receive the notification, right, soon by the arbitrator. Then arbitrator by himself or herself not doing it. They come here and they inform the dates to the labor department, right? The IR division. The IR division, they call them based on the arbitrators, the availability.
So they decision from who to appoint is taken by the commissioner.
Sorry.
To appoint the arbitrator for the
Is for the commission. Right? For the commission. If both parties to the dispute, right, agrees or consent to refer the matter for arbitration, industrial dispute, that is called voluntary arbitration. Then the documents are, prepared, and arbitrator will be appointed. The letters goes to arbitrator and the other parties, and getting the date from the arbitrator, labor authority, inform the parties, and the arbitrator will come and discuss with them. Sometimes, the written submission and oral submission, right, asking many questions, relevant questions. Finally, the arbitrator will give an award to the Commissioner General of Claim.
So the other party, the employer and the employee will be communicated. That's the appointment of the arbitrator.
Because all documents are copied to both parties. Right? Otherwise, how do they know, right? Whether arbitrator.
They don't give a date and
No. Because the appointment, there is a procedure, right? Say voluntary means commissioner can refer the matter for arbitrator if both parties consent to do so, right? Then commissioner, right, by looking at the the pool of arbitrators, right, how many works have been allocated for each other, right, looking at who is available. So the matter will be referred for that arbitrator, and the document will be prepared and signed by the commissioner, if voluntary, and it is gazetted as well, right? Sent to both parties, arbitrator and the both parties. Then it is the duty of the labor department, once it is referred for an arbitrator, discuss with the arbitrator and getting date from the arbitrator, first day sometimes. The second day, arbitrator will announce the second day. The labor department officials, the clerical staff are supporting to an arbitrator because they come here, here, labor department, the old building, in the even new building, right? They have separate rooms for arbitrators and the industrial court arbitrators as well. They come here and summon both parties. Finally, it's a settlement, right? Settlement. Ask many questions and listen to them, gather information, the document, everything. Finally, the arbitrator gives an award, right? It is called award, pradhanaya. Award. Award means the arbitrator say, the calling dates, how many days, right? What are the, the points discussed, right? Arbitration. Arbitrator has nothing to do with conciliation.
Will not put any.
No, because he will refer to the reference given by the commission. Reference means what is dispute.
Because what that we say, sometimes certain evidences are given at the conciliation stage to the commissioner. But then,
But if arbitrator wants, they can ask the labor department. I mean IR division. They have everything. But arbitrator, the should be neutral, right? And when they are summoning, both parties can submit their what they have submitted already. Again, I mean, arbitrator has nothing to do with conciliation. Right? They can gather some information, but arbitrator is not supposed to give an award based on the document of at the labor department. No, they have to summon both parties and ask them his problem and everything from the beginning onwards, and then finally, analyzing everything. It's a settlement, right? Remember settlement. So arbitrator will write, okay, these are the steps that have been taken, right? What the evidence or the documents, the communication from the trade union and the employer, both sides, right? Listen to both sides, and the arbitrator has listened to both parties, and they have presented these documents based on these. Right? I recommend, right? If it is a strike, to pay or not to pay, right? Back wages during the strike period, right? No harassment to be, any harassment to the something like that, right? Back wages or not, and if it is, the salary increment, whether salary increment to be granted or not, and then how much, something like that. So award, that is what we call award. That award is given to whom? Commissioner, if it is voluntary arbitration. Then it is the duty of the commissioner to convene the award to the parties. If employer has to pay something, it is notified to the employer that, hey, look, the arbitration award is this. The employer is supposed to adhere to the award of an arbitrator. Okay? If not, I will come to that part later. Okay? Is it clear to you or not?
so basically, to
Based on just an equity principle, he or she should give an award.
irrespective of what the company policies are or
No. The arbitrator is not bound by the contract of employment or company policies, but the arbitrator can require, right? But he should focus the law, Industrial Dispute Act, this separate chapter in the Industrial Dispute Act, right? With regard to arbitration, what is the power of an arbitrator, right? How he should act, everything is there. Right? If you need, you require, but I have, exactly the points from that part. That is what I'm going to discuss you. Otherwise, if I put here the Industrial Dispute Act, go one para by para, it's useless, right? That is not lecturing. I have highlighted here everything. What Industrial Dispute Act says about arbitration. Okay. Right.
So, now, two decisions will come out, one favor of the employee and the other one.
Dismiss. Right.
Yeah, dismiss.
Dismiss.
So, if it's dismissed,
Dismiss in the sense, the arbitrator can say there is no dispute. There is no dispute.
on that, can the employer take any sort of action against the employee for?
No. No. Right. If, say for example, if dispute is dismissed, there is no dispute. Dispute referred, dispute is referred for an arbitrator. Arbitrator says, by looking at everything, listening to both parties, and finally decides there is no dispute. This is not an industrial dispute. So then, what employer has done is correct. Okay. I don't know what, anything in relation to industrial dispute. Employment, non-employment, terms of employment, right? Conditions of employment, termination of employment, and reinstatement of employment. Anything difference between employer and workers in relation to those areas. That is what we mean by industrial dispute. Okay.
So I asked you what said, it's no dispute. Then, employee unnecessarily escalated an issue guard
Yeah.
Based on that, the can ask.
So look, then no dispute against the award of an arbitrator. If say arbitrator says there is no dispute and dismiss, no dispute, then the trade union has right to go to court of appeal against the award of an arbitrator. Right. So either party can go to court of appeal. Okay, right. So powers of the minister in settlement of dispute, section 4, compulsory arbitration. Refer the dispute to arbitration or labor tribunal means they arbitrate, forget about labor tribunal, for settlement. Settlement, right? And refer the dispute to industrial court for settlement. What is the difference between this section 4? This is compulsory arbitration, both. What is the difference between the first one and the second one, industrial court and arbitration? Yeah, many cases, right? Minor cases are referred for arbitration and the major cases are referred for industrial court. Court is, remember, not a just separate court, right? It is a, pool of arbitrators appointed by the president based on the recommendation of the Minister of Labor for 3 years, right? For 3-year tenure or period. So, minister may select maximum 3, right, arbitrators from the industrial court, and matter will be referred for that pool of arbitrators. That is what we mean by industrial dispute. Sorry, industrial court. Right? ඒක වෙනම කෝට් එකක් එහෙම නෙමෙයි ආ. මේ ලේබර් ඩිපාර්ට්මන්ට් එකේමයි කට්ටිය ඇවිල්ලා සෙටල් කරන්නේ. maximum 3. එක්කෙනෙක් ළඟ ඉතින් ආර්බිට්‍රේටර් දාන්න පුළුවන් මේ පැත්තේ. ඉන්ඩස්ට්‍රියල් කෝට් එකට දානකොට more than 1. More than 1. Industrial court now more than 1 arbitrator. They are also arbitrators. Well,
But how many
under the labor department, arbitrators are under the labor department. There are around 30, 20, 30, something like that. They all, the arbitrators for industrial court also are nominated from that pool.
Yes, these are all retired officers of full labor.
Mostly retired officers, mostly by the labor, the labor department retired officials, and most of them are lawyers as well, right? And some other senior lawyers who have dealt with industrial relation or industrial law, who has sufficient knowledge on industrial law, but majority are from the labor department. Right. The members to the industrial court also are nominated from that pool, arbitrated mostly. Okay, arbitration, two forms. I'm again repeating, voluntary arbitration, right? Voluntary arbitration, parties on their free will submit the industrial dispute to the arbitrator through the Commissioner of Labor for settlement. That is what we mean by voluntary arbitration. Commissioner of Labor to refer the industrial dispute for settlement by an arbitrator if the parties to the dispute consent to do so. එක්කෙනෙක් හරි විරුද්ධ වුණොත් කමිෂනරට බෑ. Then voluntary pay. Then compulsory. What does it mean? Compulsory arbitration. බලා කැමති වුණත් එකයි නැතත් එකයි මම බලින් දානවා මේක. So තේරෙන භාෂාවයි. So minister don't care. He does not care whether parties consent or not, because they have not given consent. That is why voluntary failed. So therefore, irrespective, ignoring or notwithstanding their consent, minister has the power to refer the matter for arbitration. That is compulsory arbitration.
So each and every, whether it's compulsory or compulsory.
Yeah.
Yeah. Is it mandatory?
Listen, right? Award is gazetted. Award is gazetted. Arbitrator is appointed. You are appointed hereby, and so these are the parties to the dispute, right? In nutshell, what labor department has done, no, it's not that. And the reference that is the definition or defining the dispute is very important. Very important.
They are not supposed to give their opinion.
Who's opinion?
Some facts that the labor commission has got.
No, because commissioner has power to settle it through conciliation. It means amicable solution. Amicable solution. Right? But when it comes to arbitrator, something like, not amicably. Arbitrator has power to, recommend relief. That is what we mean by award. The commissioner has no power to, the commissioner can, propose something, but cannot award. Commissioner's duty is to settle industrial dispute through conciliation, amicably. Discuss why don't you write and convincing both parties, amicable solution. Then 12-1 agreement will be signed. When it becomes a legal document. Arbitrator has no independence. He or she is supposed to give an award. Award කියන්නේ අපි හිතමු if we for example, right, strike will be referred to an arbitrator. Right? Basically the compulsory arbitration, right? Mainly. Then arbitrator will say, this is the strike period. Whether the strike period has to be, the workers has to be paid back wages for the strike period. How much? Half a month salary or 1 month or how is it? And then some other benefits, reliefs. What are, it depends on the situation. And it says workers cannot be like, there should not be malpractices. Workers should not be treated badly, right? Those who have, something like, those are, contained, the award contains many, not proposals, it's called, recommendation. I mean, it is, we cannot say recommendations. He said this should be done, this should be done, that should not be done. That is award. That award goes to, submitted to the commissioner. And the commissioner will gazette it and notify the parties. And then it is up to them whether they can repudiate or they can go to repudiate and go to court of appeal, either party. Otherwise, repudiation come into force after 12 months from the date of award. Award එක දීපු දවසේ ඉඳලා ඕන නම් repudiate කරන්න පුළුවන්. ප්‍රතික්ෂේප කරන්න පුළුවන් award එක. Award can be repudiated by the parties. Either party. But repudiation will come into force after 12 months from the date of award grant. Arbitrator award එකක් දෙනවනේ. මේ award එක accept කරනවනේ. එදා ඉඳලා award එක දීපු දවසේ ඉඳලා ඒකේ date එක තියෙනවනේ. එදා ඉඳලා ඒ repudiate ප්‍රතික්ෂේප කරන්න පුළුවන්. හැබැයි ඒක ප්‍රතික්ෂේප කිරීම බලාත්මක වෙන්නේ. effect වෙන්නේ after 12 months from the date of award.
කොහොමද දැන් ගෙවන්න කිව්ව කියලා employer-ට
Oh,
1 million ගෙවන්න කිව්වා.
okay, 1 million, right? Award is there is 1 million, right?
එතකොට the inception itself they don't agree. Then they go to court of appeal,
Yes.
right? Then there is no repudiation.
I mean, repudiation means, they have to write to the commissioner. We do not agree, right, with the award, and we go for that is repudiation, right? We do not agree, and it has to be copied to the other party as well.
හැබැයි ඒකට අවුරුද්දක් ඉන්නවා.
Don't misunderstand. අවුරුද්දක් අතුලත බලාත්මක වෙනවා කියන්නේ මොකක්ද? You as an employer, right? I'm the arbitrator. I, award, right? For 10 workers, 1 million has to be paid. Okay. You immediately, once you receive this, what you call this award, you write to Commissioner General. We are not in agreement with the award, right? We repudiate, ප්‍රතික්ෂේප. And the employer may mention that we go for court of act, right? By way of writ appeal. Okay. Sometimes employers do not go to court of appeal, right? But repudiate. In writing, the commissioner is notified that we are not bound by, we don't agree with the award. We are not paying. That, the written submission, written, communication to be communicated to other party as well, right? Then your repudiation will come into force after 12 months from the date of award granted. It means that Labour දෙපාර්තමේන්තුව උඩ බලාගෙන මාස 12ක් යනකම් හිටියොත් ඔයා කෝට් ඔෆ් අපීල් ගියෙත් නැහැ. ඔයා ප්‍රතික්ෂේපය බලාත්මක. එතන ඉවරයි. That is one, repudiation will have effect. අනිත්‍යව තේරුම් ගන්න එපා. Repudiate කරපු එක effect වෙන්නේ මාස 12කට පස්සේ. ඒකට හේතුව තමයි මාස 12 ඇතුළත employer ට පුළුවන් immediately mix එකක් යන්න, right? No issue then. No, හැබැයි ඒක notify කරනවා. Otherwise, the commissioner will go to court of appeal, magistrate court to implement the award. ඊට කලින් labor department එකට කියන්න ඕනේ. Right? Whether the employer is willing to go to court of appeal. හරිද? court of appeal යනවායි කියලා කියනවා. අවුරුද්දක් යනකම් ටික කාලයක් යනකම් යන්නේ නැහැ. හරි? යන්නේ නැහැ. labor department එකත් බල ඉන්නවා. Repudiation will have effect after 12 months from the date කියන එකේ තේරුම තමයි. ඔයා court of appeal යන්නෙත් නැහැ. labor department එක මොකුත් කරන්නෙත් නැහැ. හිතන්නකෝ. මාස 12ක් ඉවරුණාට පස්සේ ඔයාගේ ප්‍රතික්ෂේපය නිකම්ම බලාත්මකයි. ඒ කියන්නේ award එක implement කරන්න බෑ. ඒකයි ඒ කියන්නේ. ඒ මාස 12ක් දීලා තියෙන්නේ labor department එකට court of appeal දී නැත්නම් ඉක්මනට magistrate court එකට ගිහිල්ලා අරක implement කරා. ඒකයි මේ මාස 12ක් කාලයක් effect වෙන්නේ මාස 12කින් කියන්නේ. පැහැදිලිද? Is it clear? Everyone? හරිද? ප්‍රශ්න කරලා තමයි ඉගෙන ගන්න. That's good. But don't misunderstand. This is the way I express my view. There is nothing, personal.
Excuse me.
Yes.
Sir, arbitration එකේ decision එක enforce කරන්න පුළුවන්ද?
පුළුවන්නේ. ඒක
ඒක
අපි ඒකනේ කියන්නේ arbitration එකේ decision එක impose කරන්න තියෙනවා mechanism එකක්. දැන් arbitrator award එක දුන්නාම ඒ award එක අපි parties වලට දැනුම් දෙනවනේ. එතකොට අපි employer ට ඔන්න strike period එකේ පඩි ගෙවන්න කියලා කියනවා. හරිද? එකක් උදාහරණයකට ගමුකෝ strike එකක් තිබ්බා. strike එක settle වෙලා arbitrator කියනවා මේ strike එක මෙහෙම ගියාට සේවා යෝජකගේ පැත්තෙමුත් වරදක් සිදු වෙලා තියෙනවා. මේක වළක්ව දාන්න තිබුණා. ඒ නිසා ඒගොල්ලන්ගේ ආදායම් මාර්ග අහිමි වෙලා ගියා. ඒ නිසා ආපමන්ත මොනවා හරි පඩි ගෙවන්න කියලා එක ඕඩර් එකේ තියෙන එක කන්ඩිෂන් එකක් කියමුකෝ අපි. හරිද? මේක ඉම්ප්ලිමන්ට් කරන්න නම් ඒ කියන්නේ මේක ප්‍රතික්ෂේප කරන්න පුළුවන් සේවා යෝජකයාට. රිපියුඩියේට් කරනවා කියන්නේ ඒක ප්‍රතික්ෂේප කරන්න පුළුවන්. ඒ ප්‍රතික්ෂේපය අංකරු කොමසාරි ජෙනරාල්වරයාට සහ ට්‍රේඩ් ඒකට සම්බන්ධ අනිකුත් පාර්ටියකට ට්‍රේඩ් යූනියන් එක නම් ඒකට ලිඛිතව දැනුම් දෙන්න ඕන. අපි මේකට එකඟ නැහැ කියලා. හරිද? එහෙම කියලා හැබැයි සේවා යෝජකයා එහෙම කිව්වා වගේම ඊළඟට යාට තියෙන ඒක යා පිළිගන්නේ නැත්නම් එයාට තියෙන ඊළඟ ඔප්ෂන් එක තමයි immediately ඕකටද රිට් ඇප්ලිකේෂන් එකක් දාන්න ඕන court of appeal එක. හරිද? ඒක දාන්න නැතුව එයා රිපියුඩියේට් කරනවා. හරිද? ප්‍රතික්ෂේප කරලා කම්කරු කොමසාරිස්ගෙනාට ලියලා යනවා. එයා court of appeal යන්නෙත් නැහැ. හරිද? යන්න නැතුව ඔහොම ඉන්නවා. දැන් මං කියවනේ the repudiation will have effect after 12 months from the date of award කියලා. ඒකේ තේරුම තමයි repudiate කරණීම ලිඛිතව දන්නවනවා. හරිද? කොමසාරි ජෙනරාල්ටයි අනිත් පාර්ටියට. ඒකල මෙයා court of appeal යන්නේ නැතුව ඉන්නවා. සේවා යෝජකයා. එතකොට අවුරුද්දක් ඇතුළත ඔය අවුරුද්දකින් මාස 12කින් ඉෆෙක්ට් වෙනවා කියන එකේ තේරුම ඒකයි. කියන්නේ මාස 12ක් ඇතුළත ඉමීඩියට්ලි මාස 12ක් බලන් ඉන්න හොඳ නැහැ. ඒක ඉම්ප්ලිමන්ට් කරන්න කොමසාරිස් ජෙනරාල් කොහෙටද යන්න ඕන? මහේස්ත්‍රාත් අධිකරණයට යන්න ඕන අවෝඩ් එක
through the court එක enforce කරන්න ඕන.
මොකද්ද?
You should go through the courts to enforce it.
Yes, to enforce it has to go to through the court, magistrate court to enforce the award. In case labor department fails to go to court of the magistrate court within 12 months, within that 12 months, right? Nothing can be done. Nothing can be done. So therefore, it is the duty of the parties, mainly the trade union, to inquire with the commissioner whether the employer has filed a case with the magistrate court. Otherwise, immediately, without waiting for months and months until 12 months, the commissioner should file the case with the magistrate court in order to implement the award, arbitrator's award. Is it clear?
So ඒ award එක arbitration board එකකින් දීපු award එක fair නැත්තම්
නෑ බෝඩ් එකක් නෙමෙයි ආබිට්‍රේටර් කියන්නේ. ආබිට්‍රේෂන් බෝඩ් එකයි පටලව ගන්න එපා. අධිකරණ අමාත්‍යාංශයේ තියෙන ආබිට්‍රේෂන් බෝඩ් එකයි මේකයි වෙනස්. ඉන්ඩස්ට්‍රියල් ඩිස්පියුට් ඇක්ට් එකේ right. මෙතන ආබිට්‍රේටර් වෙනම pool of arbitrators are there under the labor department, right? The registered of arbitrators. The
who are
case,
the officers?
I told you repeatedly, arbitrators, most of them are retired labor departmental senior officials. Most of them. Most of them. It's not an arbitrator like under the what do you call the justice ministry, No.
Okay. They look into the only the facts, not the law, no?
Not the law. Right. They are governed only by the Industrial Dispute Act. None other than no any other law.
Okay.
For commission, court the order to state court. That's right.
Magistrate court. That is right. Repeatedly, please understand. Within 12 months, කියන්නේ මොකද්ද? නෑ. Repudiate කරක් නැතත්. Right? Repudiate කරක් නැතත්. 12 months වලින් යන්න ඕනේ. Before 12 months. එහෙම නැත්නම් කර්මයට repudiate කරලා තිබුණොත් එහෙමයි. Repudiation එක වළංගු වෙනවා මාස 3ක් ගියා. ආයි මැජිස්ට්‍රේට් කෝට් යන්න බෑ. Committee, what arbitration committee? Arbitration. Oh. ඒ ඇග්‍රී වෙන්නේ නැති එකට අපි කියන්නේ කන්සිලියේෂන්. හරිද? කන්සිලියේෂන් එකේදී තමයි ඇග්‍රී වෙන්නේ. right? සමහර වෙලාවට ආබිට්‍රේටර් ළඟ ඇග්‍රී වෙන්නත් පුළුවන්. නොවෙන්නත් පුළුවන්. එතකොට ආබිට්‍රේටර්ට තියෙනවා පව එකක් බලයක්. එයා just and equity principle එක මත ඉඳගෙන එයාගේ award එක ප්‍රදානය දෙන්න. මේක තමයි. settle වෙනවා නම් එතෙන්දී හොඳයි. settlement කියලානේ කියන්නේ. ඕ වෙලාවට වෙන්නේ නැහැ. සමහර වෙලාවට වෙනවා. සේවා යෝජකයා හරි සේවකයාත් අගතියටපත් වෙනවා. ට්‍රේඩ් යූනියන් එක හිතනවා නම් මේ award එක වැඩක් නැහැ කියලා. right? මේ award එක අපි කියපු දේවල් නෙමෙයි කියලා එයාට යන්න පුළුවන් කොහෙටද court of appeal එකට. right? දෙන්නේ මෙහෙමයි. ඉස්සෙල්ලා court of appeal එකට යනවා කියන එකේ තේරුම right? කමිෂනරට නොකිය යන්නත් පුළුවන්. කමිෂනරට නොකිය court of appeal, කමිෂනරට නැඳුම් නොදී court of appeal යන්න පුළුවන්. ඒ කමිෂනර් දැනගන්න ඕන එම්පෝස් කරන්න යනකොට මැජිස්ට්‍රේට් එකට යන්න කලින් පිට් එකක් දාලාද නැද්ද කියලා. හරි. ඒකනේ ලීගල් ඩිවිෂන් තියෙන්නේ මේක ඇතුලේ. ඒක ඉන්ඩිපෙන්ඩන්ට් පුළුවන්. ඒක චෙක් කරන්න පුළුවන්. ඔය ආබිට්‍රේෂන් එකේ උත්තරයක් හම්බුනේ නැත්නම් සමහර ස්ට්‍රයික් කරන්න ඒවත් යනවා. නෑ. ආබිට්‍රේෂන් එකෙන් උත්තරයක් හම්බෙන්නේ නැහැ කියන එක පටලව ගන්න එපා. Arbitrator is given an award. එයා කියනවා මේක කළ යුතුයි මේක this has to be done, this has not to be done, right? කියනවා. That is award. Right? Bound by the parties. But anyone agree, they are not agreeable, they can repudiate. Without repudiating, they can go to court of appeal. Or sometimes most of them what they are doing is, they write to the Commissioner General repudiating, right? We repudiate, ප්‍රතික්ෂේප කරනවා and intend to go to court of appeal.
Sir, excuse me.
Yes.
ඒක ඇවිල්ලා සර් ජජ්මන්ට් එකකුයි ඩිසිෂන් එකකුත් නෙමෙයි award එකක් විතරයි.
Award එකයි විතරයි. Judgment දෙන්න බෑ labor department එකට.
It can be accepted or refused, no?
Yes, accepted or refused. Accepted නම් ඒකට adhere වෙන්න ඕනේ.
adhere වෙන්න ඕන.
adhere වෙන්න ඕනේ. refuse කරනවා නම් refuse කරලා court of appeal යන්න ඕනේ.
ඊළඟ පියවර ගන්න ඕන.
දැන් labor department එකකින් magistrate within 12 months ඇතුළත අවුරුද්දක් ඇතුළත යන්න ඕන මේ magistrate court එකට.
ඔව්. එහෙම ගත්තේ නැත්නම් ඒගොල්ලෝ enforce කරනවා through the courts. අද award එක.
Yes.
Right. හරි, okay. තේරුණා
Right.
සර්.
Even now, after, magistrate, for example, magistrate affirm give the decision in favor of arbitrator. I mean, arbitrator is correct. So the
ලේබර්
employer,
ඩිපාර්ට්මන්ට් දැනගන්න කොහොමද මැජිස්ට්‍රේට් කෝඩ් ගියා කියලා?
you have to mute your microphone, Olga Pereira. If you have anything to ask, please ask. Otherwise, mute your microphone. So then, so award is granted. I mean, magistrate court order to pay the employer. Again, employer, right? The employer can go to High Court. I will come to that part. Very nice picture is there, with arrows and summarized part, right? You will see it later. How to impose, right? So this is voluntary. Ahmad,
Yes,
is it clear?
Yes, sir. Clear, very clear.
Right. So reference to arbitration. Commissioner of Labor is to prepare a specific reference, unambiguous, for arbitration. Specific reference කියන්නේ document, appointment letter, මේවා copy කරන්න ඕන කොහොමද? But very important is, who are the parties and what is the dispute. That is what we mean by reference. It should be unambiguous, very clear. Let me share my experience with you. Being the Commissioner General of Labor, I have referred, many cases for an arbitrator. Okay, Assam is But when it comes to the compulsory arbitration, the commissioner has to prepare all document, and commissioner is supposed to send it to the secretary to the line minister, because the commissioner cannot approach the minister directly. The minister, all documents should be submitted to the minister through the secretary. Right? As I was there as the Commissioner General of Labor, I used to every time, being the secretary, I used to read the reference. එක දවසක් මට අහු වුණා. 8 පේලිය reference එක වැරදි. Reference එක වැරදි. There was a strike. This is real case. There was a strike. Government එක නම කියන්න හොඳ නැහැ. Famous one. Government. Reference. The IR department is supposed to prepare, the reference and all documents. This is a document file. Appointment letters, reference. Reference the strike settle කරන්න දැන් මෙහෙම ස්ට්‍රයික් එකක් ගියා. ඒ අනුව මේ ස්ට්‍රයික් එකේ සාධාරණද අසාධාරණද එහෙම නැත්නම් මේකේදී මේ අයට අයුක්තියක් සිදු වෙලා තියෙනවද කියලා තමයි බලන්න ඕනේ. මේක ලියලා තියෙන්නේ මොකක්ද දන්නවද? සේවක වෘත්තීය සමිතිය වෘත්තීය ක්‍රියාමාර්ගයක් ගැනීමේදී සේවා යෝජකයා යම් ආකාරයකට සේවා යෝජකයාගෙන් සේවකයන්ට අසාධාරණයක් සිදු වේද යන්න සොයාගන්න. ගැළපෙන්නේ නැහැ මේක. ඒ කියන්නේ ස්ට්‍රයික් එක සෙටල් කරන්න දාලා කාරණා වෙනුවට ස්ට්‍රයික් එක හේතු කොටගෙන ස්ට්‍රයික් එකේ ඉන්න කාලේ හාම්පුතා මොනවා හරි කරාද කියලා හොයපන් කියන එකදී. It's not dispute. අරවල ඇරියාපන්. එන්නලා කමිෂනර්ට හොඳට දෙකක් කිව්වා. Reference should be very clear, unambiguous. It has to be explained. These between these and the industrial dispute, strike has, the taken. Strike is the result, no, right? Strike has taken place based on what? Based on what? Right? මෙහෙම වැටුප් වැඩි කිරීමක් ඉල්ලා මෙහෙම උද්ඝෝෂණය ඒ වැටුප් වැඩි කිරීම සාධාරණද? කොපමණ ප්‍රමාණයකින් වැටුප් වැඩි කර යුතුද? යන්න තමයි ඕඩ් එක දෙන්න ඕනේ. ඒ වෙනුවට වෙන අටමඟලක් ලියලා. එහෙම වුණාම හොයන්න කියන්නේ ස්ට්‍රයික් කාර්යයකට සේවා යෝජකයා මොනවා හරි අරගොල්ලන්ට කළාද කියලා. ඒ නිසා the reference should be very clear and it is the duty of the commissioner to prepare the reference and unambiguous reference and for an arbitrator. Matters should be determined, should be clearly spelled out. මොකද්ද විසඳන්න ඕනේ කියන එක clearly spelled out. Section 16 commissioner's statement කියලා මේකට කියන්නේ. Right? Well, Section 17 procedure for arbitration. Arbitrator assume jurisdiction on reference. On reference, what does it mean? What do you mean by reference? Reference made by the commission, the commissioner's state. So, arbitrator assume jurisdiction. යාර jurisdiction එන්නේ on reference. නැතුව evidence ordinance වෙන නීති වලින් නෙමෙයි. Only the reference. Right? They take steps for preparation of the case for hearing. Case එක අහන්න prepare කරන්න ඕනේ. Right? Preparation. The labor department will support. There are some sections, venomous section එකක් තියෙනවා. So arbitration. Here arbitrator should be arbitrator, right? Here such evidences as may be tendered by the parties to the dispute and can it demonstrator අහුම්කම් වෙන්න ඕනේ. Natural justice should be followed. What do you mean by natural justice?
Fair and equitable.
You know, when the award should be just and equity principle, right? Just and equity principle means the one element is the arbitrator should follow the natural justice as well. Right? You know, without following the natural justice, you can't give just and equity principle, but the judgment, award based on just and equity principle. Right? The natural justice is, there are two elements. One is you have to listen to both parties. The arbitrator is supposed to listen to both parties. And second, no one hear his own case. තමාගේ නඩුවේ තමාම විනිශ්චයකාරයෙකු නොවිය යුතුයි. Again, should very neutral. Arbitrator should be very neutral. Right? Very neutral. Right. And make a just and equitable award as may appear to arbitrator. So that means arbitrator has some discretion to determine, but based on just and equity principle. Okay? යුක්තිය හා සාධාරණත්වය මත පදනම් වූ ප්‍රධානයක් ලබා දිය යුතුයි. Okay? Right. Well, now the next one, the industrial code, same as arbitration, same principle. The difference is the minor disputes are referred for an arbitrators. Only case is minor, only one arbitrator. Under the Industrial Dispute Act, there is a provision for industrial court as well. Right? Arbitration, this is industrial court also arbitration. Right? They must give just and equitable award. What is then difference? Difference, if there are major matters, one arbitrator cannot solve it sometimes. Cannot, it's complicated. So therefore, out of the pool of arbitrators, maybe outsiders as well, based on the recommendation of the minister in charge of the subject of labor, the president appoints arbitrators to the industrial court for 3-year period. 10 දෙනෙක් විතර ඕක ඉන්න බෑ maximum. So ඒක වෙනම කෝට් එකක් එහෙම නෙවෙයි. මේ ලේබර් ඩිපාර්ට්මන්ට් එකේ තියෙන උඩ පොඩි කාමර. ඉතින් කාමරයක් හොයලා දෙනවා ඉන්ඩස්ට්‍රියල් කෝට් එකට මැට එකක් රිපෝට් කරනවා. What does it mean? Maximum 3 arbitrators from the court are appointed to settle the dispute and give just an equitable award. Major matter, not only one arbitrator, 2 or maximum 3 arbitrators. So that is the difference between industrial court and there is another difference as well. I will come to that point later, but as I told let me explain that one as well. If once arbitrator gives an award, aggrieved party has no chance. No chance in the sense, no appeal procedure. Directly they have to go to court of appeal. Right? If either party does not agree with the award, they can directly go to court of appeal against the award. But when matter is referred for an industrial court, there is one more step. What is the step? Before go to court of appeal, the aggrieved party, affected party, who has objection to the award, can appeal to the minister to reconsider the award. Because major matters are referred for, right? Referred for industrial. Matter is complicated. Sometimes trade union, may not have either part, may not have, the significant financial, the capability to go to court of appeal. Matter is, so complicated. So therefore, the chance has been given to a party, who the party does not agree with the award of the industrial court. They can again appeal to the minister, asking to reconsider the award. Then minister think, yes, it could be rethink, reconsider. Then the minister will appoint another arbitrators from the industrial court. Another pool of arbitrators. Otherwise, they can include party, they can directly go to court of appeal. If it doesn't agree, then no choice. Right? Because in my last couple of months, the one trade union guy, little controversial man, right? So influential internationally. The one matter, in relation to their trade union, was referred for an arbitrate. Once the award is granted, the trade union, they was unhappy. They were unhappy. They approached to the minister, and not to minister. The trade union, written to minister and copying to me. Please, we are not satisfied with the award of an arbitrator, not industrial court, arbitrator. And under section 27 of the Industrial Dispute Act, 27 years, Industrial Dispute Act, we are appealing you to reconsider this award. That is the letter. The minister asked, said no. 27 section, yes, 27 if I'm not mistaken, is with regard to the matters referred for industrial court. That matter has not been referred for industrial court, but for an arbitration. So therefore, you are not entitled to appeal this one. Minister has no power to reconsider this award because the matter has been referred for an arbitrator, not to industrial court. So therefore, the remedy that you have is, if you are disagree, there is a procedure for you to go to court of appeal. Okay, right. Shall we break for tea? What is the time now? Yeah, 10:30, 10 minutes. Because we have many, because these are not just the textbooks. Right? So many questions. Oh, award එකක් දෙනවා. ඒක affirm කරනවා. ඕ set aside. දෙකෙන් එකයි දෙන්නේ. award එක හරි කියලා කියනවා. නැත්නම් award එක arbitratorගේ award එකට එරෙහිවනේ යන්නේ කවුරු හරි court of appeal. එතකොට court of appeal එකට ගියාම එරෙහිවනේ යන්නේ. application එක entertain කරන්නත් පුළුවන්. application එක dismiss කරන්න. entertain කරනවා කියන්නේ මොකද්ද? award එක වැරදි. හරිද? application එක dismiss කරනවා කියන්නේ මොකද්ද? award එක හරි. හරි. දැන් මෙහෙමයි. එතනින් විතරක් නෙවෙයිනේ. ඊට පස්සේ සුප්‍රීම කෝර්ට් යනවානේ. ඊට පස්සේ කොහෙද යන්නේ? සුප්‍රීම කෝර්ට් යනවා. දැන් ඩිස්පියුට් එකක් කියන්නකෝ. හරිද? මම පස්සේ කියන්නම් මගේ ළඟ කේසස් වගේක් තියෙන ඒවත් එක්ක අහන්න. හරි? ඒ කියන්නේ industrial dispute arises mainly labor authority tries to settle amicably through conciliation. Right? That is the procedure. You can't just jump to arbitration. At least 1 or 2 times you have to conciliate. If failed, then voluntary arbitration, or if failed, the compulsory arbitration. Whatever the voluntary arbitrator or compulsory arbitrator gives an award just based on just and equity principle. Right? Say for example, a minor matter. Right? For couple of years, you are entitled for the next position. Next position. Right? Next, the higher position. But you are discriminated. Sometimes the junior to you may be appointed, right, to that position. Then you are the one who aggrieved part. First, you lodge a complaint with the labor department. Okay? So then, labor authority summon you and the other party, employer, tries to settle amicably. Right? You experience and many things, right? You acquire knowledge. So why the employer can't, what do you call this, consider this? Sometimes maybe your ego, or sometimes the director board doesn't know, the partners doesn't know anything, right? Your immediate supervisor, or the corporate director or someone, right? May have some personal thing, right? You have been discriminated. So then employer does not agree. Then matter will be referred for. Conciliation failed. Matter will be referred for an arbitrator. Arbitrator gives an award. Right? Say, for example, award says that you are entitled for that position, and the employer is employer asked to kind of an order, but we don't say order, it's an award. Employer has to promote you to that position, right? So that is the award. if employer does not agree, or employer can refuse it, repudiate. ප්‍රතික්ෂේප කරන්න පුළුවන්. So repudiation can be, communicated to the Commissioner General, right, and to you, right? So then repudiate, right? The employer, and then immediately employer has to go to court of appeal, right, against the award, because award has been given in favor of you. The employer disagree with that. Then the remedy is the employer can go to court of appeal. So sometimes what employers does, they just write to the Commissioner General, right? Or in case you example, right? So saying that the award has been so and so granted, right? We are not in agreeable, right, with the award. Copying to you. Okay? Well, then they don't employer doesn't go to court of appeal, waiting. Right? Just repudiate. Repudiate means ප්‍රතික්ෂේප කරලා ලියුම යනවා. ඉතින් බලන්න ඉන්නවා යන්නද. So yeah, that repudiation will come into force after 12 months from the date of award grant. Award එක දීපු දවස් ඉඳලා මාස 12කට පස්සේ තමයි ප්‍රතික්ෂේප කිරීම බලාපොරොත්තු වෙන්නේ. ඊට කලින් ඒක ඩිපාර්ට්මන්ට් එක මාස 12 දීලා තියෙන එකයි. ඒක කියන්නේ මාස 12ක් ගියොත් එහෙම after 12 months an employer doesn't need to pay, doesn't need to promote you, because award becomes inactive after 12 months, right? So therefore, before that 12 months, it is the duty of the labor department, looking at whether the employer has gone to court of appeal or not. If not, then file the action with the magistrate court in order to implement the award given in favor of, right? And the magistrate court affirm the award. It means that the decision will be given in favor of you. It means that the application of your employer dismissed. Then it means employer has to adhere to the award. If still employer feels that no, I'm not that, then next step, go to Supreme Court against the decision of the court of appeal. Okay. At the same time, okay, employer neither refuse but doesn't go to court of appeal, then the labor authority should go to magistrate court in order to implement the award. Okay, the given in favor of whatever, right? And then magistrate court affirm the award of an arbitration. It means that employer is ordered to promote you. At that time, employer disagree. Employer say disagree. Then against the magistrate court decision, employer can go to High Court and then Court of Appeal and then Supreme Court. Right? It's very complicated.
So Supreme Court you can do twice.
No. At once, right? Court of Appeal. If you are not going to Court of Appeal, the next step comes after decision of the magistrate court. Right? The employer directly go to Court of Appeal, then the Supreme Court. But employer neither adhere to the award, no approach to the Court of Appeal as well. Employer decision award එකට adhere වෙන්නේ නැහැ. Court of Appeal යන්නේ. එතකොට labor department එක යනවානේ magistrate court එකට. එතකොට magistrate court එකේ decision එකට against High Court and again Court of Appeal, again Supreme Court. Bench එක සාමාන්‍යයෙන් මෙහෙමයි. ඒක කීයක්ද කියලා අපිට කියන්න බෑ. right? ඒක මෙහෙමයි. දැන් 3 bench එකක් වුණා නම් 3 bench එකේ decision එක වෙනස් කරන්න. කියන්නේ 2 bench නම් 3 bench වලට යන්න ඕනේ. 3 bench නම් 5 bench. එතනින් එහාට ගයක් නැහැ.
ඒක දෙපාරකට නෑ.
ඔව් දෙපාරයි. That is why, right, we have to settle the disputes amicably. Settlement is the most important one without going for litigation. Even at the arbitrators are trying to settle it because matter is referred to an arbitration for settlement. Right? Settlement.
So arbitration level එකේදී either party can call the labor officer who did the was part of the settlement process as a party to give some evidence.
No. They could, because the labor officer is an independent person. So you can bring some outsider as
දැන්
Right.
යාව කියනවා මම කියන්නේ ඒකේ තියා පාටි එකක් හැටියට දාන්න
bad. This is not a court, right? Remember, arbitrator is an independent, person. Arbitrator should focus only on the reference and get other information in relation to the reference from the party. Arbitrator does not have any jurisdiction to call labor officer or the devoto. No. But they can ask the Commissioner General if supporting document something. No, they can ask, arbitrator can ask. But that is why arbitrator, once arbitrator, matter is referred for arbitrator, both parties, right? It is their duty to, the convince. It is their duty, not the labor officer's duty. It is the party's duty to convince the arbitrator.
basically has to start from the inception.
Yes, inception. But the arbitrator is brief, no? Make it brief reference එකට අමතරව
ඒක දෙනවා.
ඒක දෙනවා මොනවද කළේ මොනවද පේන්නේ මේවා ටිකක් තියෙනවා. Right, well, right, පුළුවන් right මේ ඒක ඉතින් පොතපණ තියෙන්නේ
ඒක අපිට යන වෙලාවෙ කෙනෙක්
arbitration එක යන වෙලාවේ observers හැටියට ඉල්ලන්න පුළුවන්
ඒ වගේක් බෙන්ච් කරලා දෙන්න බෑ.
තමයි then put so we will break for 10 minutes, right? 10 minutes for break, 10 minutes break. Ladies and gentlemen, 10 minutes break for tea. Well, let's start. Right. So we have many things to be covered. Happening. Industrial court. The same thing. Only difference is, court is separate body. More than one arbitrator will be appointed. Major cases will be referred for industrial court, whereas the minor matters referred for an arbitrator. Right? The procedure is same. So, in respect of matters referred to, make all such inquiries and hear all such evidences as it may consider necessary, and take such decision or make such award as may appear to the court just and equitable. Right? And this is important what I said. Right? What? Review of awards made by arbitration or by industrial court. Don't misunderstand. There is no possibility to review the arbitrator's award. Review is possible only for the award granted by the industrial court, right? So no appeals lies against arbitrator's award. No appeal, but writ directly. Okay? Appeal lies against industrial court award, and that to be heard by another industrial court. If appeal to whom? Appeal to the minister, because industrial court is appointed to hear the case dispute by the minister. So appeal should send to the minister, ask him to reconsider the award. Then if minister feels or think that it can be reviewed, then minister can appoint not the same pool of the industrial court, another industrial court to look into the matter. Okay? But for both judicial review, by way of writ is available in the Court of Appeal and then to the Supreme Court. ඕන නම් appeal එක නොකර Court of Appeal යන බාධාවක් නැහැ. There is no barrier. But appeal is possible only for the award made by an industrial court, not against the award made by an arbitrator. Industrial court එකට refer කරොත් විතරයි ඒ award එක review කරන්න කියලා appeal එකක් කරන්න පුළුවන් minister. Arbitrator ගේ award එක appeal කරන්න බෑ. හැබැයි මේ දෙකටම රෙහිව යන්න පුළුවන් කොහෙටද? Court of Appeal එක. Is it clear, everyone? Right. So remember, there are things you need to understand. Award decisions, not award, decisions, if the orders, decisions and award, orders, not decisions, orders can be appealed. Award, decisions against award and decision should go to decisions of the commission, right? That is the procedure. Remember, in the in industrial law, aggrieved party directly can go to, in industrial law, under the Industrial Dispute Act, or whatever the commissioner in the Industrial Dispute Act, remember, commissioner is trying to settlement. Okay. If cannot be settled amicably, then the arbitration. Right. Arbitration gives an award. Industrial court gives an award. Against award, the legal remedy is not to appeal, but directly go to court of appeal. I can't say why. That is the procedure. There are orders, decisions, awards. Okay. Against orders and decisions can directly go to court of appeal. Decisions by the administrative board. ඒ කියන්නේ මේ ආර්බිට්‍රේට් කියන එකත් පත් කරන්නේ කවුද? ඇඩ්මිනිස්ට්‍රේෂන්. ඒකට ඇඩ්මිනිස්ට්‍රේෂන් ඩිසිෂන් එකක් වගේම තමයි ඒක. ඒකට ඒකකට එරෙහිව අපේ රටේ තියෙන යන්න තියෙන ලීගල් ප්‍රොසීඩියර් එක තමයි court of appeal. orders දෙන්නේ කොහෙන්ද? in the industrial law එකේ industrial law එකේ orders දෙන්නේ කවුද? මේ මැජිස්ට්‍රේට් යන්න කලින් කියන්නේ මැජිස්ට්‍රේට් එක පටලවා ගන්න එපා. award දෙන්නේ කවුද? LT. Industrial law එකේ award දෙන්නේ කවුද? Arbitration and industrial court. Industrial dispute එක යටතේ under the Industrial Dispute Act. Who gives an order? LT. Under the Industrial Dispute Act, who gives an award? Arbitrator and industrial court. So, against the order, next step is against the order given by an LT, Labour Tribunal, Provincial High Court. Against the award, directly Court of Appeal. හරිද? ඒක තමයි අපේ රටේ නීතිමය සිස්ටම් එක. ඇයි කියලා මගෙන් අහන්න එපා. මම දන්නවා. ඒක තමයි අපේ රටේ නීතිය. award එකකට award දෙන්නේ කවුද? in industrial employment law එකේ awards දෙන්න පුළුවන් නේ arbitratorටයි industrial court එකටයි විතරයි. Against the award, aggrieved party, there is no other way, should go to court of appeal. Okay, but when it comes to an award given by industrial court, before go to court of appeal, there is an appeal procedure, not to the court system, but to the minister. Ask him to reconsider the award. Appeal to the minister. Right? Not to, high court or whatever. Or without appeal, they can directly go to court of appeal. Right? But when it comes to Labour Tribunal gives an order, not award. Against the order, the procedure is not to go to appeal, but to Provincial High Court. And then Supreme. No, because Provincial High Court has dual character, dual role. One is to act as Provincial High Court. The other one is Provincial Appeal Court. Also, Provincial High Court act as Appeal Court at the provincial. Okay. And then against the LT order, remember, LT order, the aggrieved party, right, dissatisfied party, the remedy is go to provincial high court. But when it comes to under the Industrial Dispute Act, I'm not referring to any other act. When it comes to industrial dispute, there are two decisions. One is award, the other one is order. Order given by labor tribunal. Award by arbitrator or industrial court. So against award, court of appeal. Against order, provincial high court. What about when it comes to TEWA, Termination Act, right? Next one I think, right? ඊළඟ එක නේද? TEWA. TEWA එකේ decision දෙන්න පුළුවන් කාටද? Commission. Commission. Decision. Against the decision, aggrieved party. Commissioner decides, right? To reinstate the workers. Court of appeal. Court of appeal. Forget about all these things. You know, you have to understand one by one, not entire thing. Act by act. When it comes to industrial dispute is something which is not in law. Not in law in the sense, let me put it this way. Industrial dispute doesn't mean that violation of law. Right? Salaries, non-payment of salaries, not an industrial dispute. Non-payment of gratuity, not an industrial dispute at all. Those are violations of I read. Conciliation. So, non-payment of gratuity, non-payment of wages, non-payment of overtime, non-payment of holidays or holiday payment. Those are violation of law. If law is violated, there is no conciliation. Why? The Labor Department, without going for the litigation, at once at least, they summon party and look into the matter and ask the employer, hey, you have violated this one, right? Within 2 weeks or 1 week, 1 month maximum, right? Are you going to adhere? Are you going to pay this one? If the employer does not adhere, Labor Department should file the case at, with the magistrate court in order to recover the money, in order to recover the gratuity, in order to recover the overtime. Those are violated very clearly. Payment, salaries, wages, gratuity, right? Overtime payment, holiday, payment of holidays, and leave. All are very clearly spelled out in law. Industry, but not giving an increment. There is no law compelling the employer to pay, give increment, salary hike. Employer would increase every year salary or wages by 10%. Where is the law? Okay, right? Promotions, bonuses. Are there any law with regard to the compelling the employer to pay bonus? No. Promotion? No. Again, dispute act. That is a dispute. Remember, cases in relation to violation of law in the land are not disputes. Dispute is something else. You are not entitled, but you are demanding. You may be entitled, but there is no legal entitlement. Bonuses are not legal. You are not legally entitled. Salary increment is no compelling the employer, forcing employer to increase the salary. අර wages code වල තියෙනවා පුංචි මේ රුපියල් 100 වගේ ගණන් increment කියලා ඒ wages code decision. ඒක වැරුණා. salary increment දෙන්න කියලා කොහොමවත් නැහැ. bonus දෙන්න කියලා කොහොමවත් law එකේ නැහැ. හැබැයි gratuity ගෙවන්න ඕනේ කියලා law එකේ තියෙනවා. right? overtime කරොත් දෙන්න ඕනේ කියලා law එකේ තියෙනවා. 1.5 times සමහරට 2 times එනවා. holiday payment ගෙවන්න ඕනේ කියලා. this is there in the law. EPF, PTF must. Salary, yes, must. You have to pay. Employer. Those are not disputes. Those are violations. Those cases are violation of law. Violation of law. Remember? Right. So, but when it comes to other matters, strikes going on, dispute. Because strike is the result, ultimate, the end situation. But before that, why strike has taken place? No bonuses has been given. No salary increment. They are demanding salary increment. No, for certain persons, certain group of people have been treated discriminated. Those are disputes. මතක තබා ගන්න. සේවා යෝජකයෝ සහ සේවකයෝ අතර රැකියාව දීම රැකියාව නොදීම ඒ කියන්නේ රැකියාව නොදීම කියන එකකින් අදහස් කරන්නේ මේ කොහෙවත් ඉන්න මිනිහෙකුට ගෙනලා රැකියාව ඉන්ටර්විව් එකට ගිහලා රැකියාව නොදීම කියන එක නෙමෙයි. රැකියාව ඉන්න ගමන් right සමහරට ඉන්ටර්විව් ඒක මොකක්ද? රැකියාව නොදී සමහර කෙනෙකුට උසස් වීමක් දෙන්න තියෙන කෙනෙකුට නැතුව වෙන කෙනෙකුට terms and conditions සමහර වෙලාවට කියනවා නෑ අපිට කියනවා මේ මොනවද ඕවර් ටයිම් කරන්න බෑ. හැබැයි Japan Office Act එකේ තියෙනවා certain number of කියන්නේ ඕවර් ටයිම් කරන්න ඕනේ. හරිද? හැබැයි ඉතල dispute එක කොච්චරද කරන්න ඕනේ කියලා. කරන්න බෑ කියනවා. So those are disputes. No clear provision. Legal provision in other law, but the provisions are there in Industrial Dispute Act. If dispute arises, how to settle it? Okay, understand? So this is industrial law in the country, very complex, right? So when it comes to industrial dispute conciliation, whatever you say, Industrial Dispute Act, all provisions in the Industrial Dispute Act to settle industrial dispute. Termination also comes under the definition of dispute, right? ඒකයි LT එකක් දාලා තියෙන්නේ මේක ඇතුලේ. Leave it right. So, whatever, if the matter, industrial dispute cannot be resolved amicably through the conciliation, commissioner cannot do it. It has to be referred for an arbitrator or the industrial court. Arbitrator and industrial court gives award. They give award against either party. They may agree, adhere, or sometimes they may refuse. So then the remedy against the award to go to court of appeal. LT gives an order. Against the order, the aggrieved party has no provision or has no jurisdiction to go to court of appeal, but to go to provincial high court. Is it clear? අනිත්‍ය පටලවා ගන්න එපා. ටර්මිනේෂන් ඇක්ට් එකට යනකොට ඒක වෙන එකක්. මේ ඩිස්පියුට්. දැන් පඩි ගෙවුවේ නැත්නම් පඩි ගෙවන්න කියලා ඕඩර් එකක්. හරි. terminate කරාම ඒකට ගෙවන්න කියලා ඔක්කයි. reset කරන්න කියලා order එක. හරි decision එකක් එන්න. not order decision. right. තමයි order කියන්නත් පුළුවන්. ඒවා decision එකට against කොහෙද යන්න ඕන? court of appeal. right. court of appeal. provincial high court යන්න තියෙන්නේ එකම එක අවස්ථාවක් විතරයි. මොකද්ද? LT decision එකට decision order එකට against. provincial high court යන්නේ ඒකෙදි විතරයි. අනිත් ඒවා යන්නේ court of appeal. Okay, well, so remember, this is very important landmark. Industrial Dispute Amendment Act number 22 of 2022. The effective date 16th of March 2022. So now, right, you know that against the award, the employer or the trade
Excuse
union
me.
can go to court of appeal.
So excuse me.
Yes.
Sir, can you repeat this thing? All appeals should go to?
Sorry.
So you said about the appeals. All LT appeal should go to where, sir?
To provincial high court against LT order, right? Against LT order, appeal should be made to the provincial high court. That is appeal procedure, right?
Okay.
Against the order, orders are given by arbitrator and industrial court, right? You know, I'm just, you have to focus the industrial dispute, only industrial dispute act, settlement of industrial dispute. Don't mess up with other things, right? Wages, you know, termination, acts of an office, don't mess up with that. Right? Only industrial dispute. So, under the Industrial Dispute Act, there are, you know, orders and awards. Orders are given by labor tribunal. Against the order, aggrieved party has to follow the appeal procedure. You can't appeal to the court of appeal. It's a by way of writ, appeal by way of writ. So against the LT order, whatever the name you call, the aggrieved party has to go to provincial high court and then after that Supreme Court. But against the orders given by an arbitrator and industrial court, directly go to, I mean, you are not supposed to, aggrieved party is not supposed to, cannot go to provincial high court, but to court of appeal by way of writ application. By way of writ application. Right? Where provincial high court එකට මේ industrial law එක පුරාම යන්න තියෙන එකම අවස්ථාව තමයි LT order එකකට against. අනිත් ඒවා හැමතැනම යන්නේ කොහෙටද? but මේකෙදි තව තැනක් තියෙනවා එහෙම වෙනස් වෙන තැනක්. වගේ එක කියන්නේ Industrial Dispute Act එක. Right? So let me, so this one, sometimes once award is granted, employers go to court of appeal. When LT orders to reinstate or pay compensation, employer goes to where? Provincial high court against the decision. Sometimes they go to Supreme Court as well. The entire period, definitely more than 8 years. To settle everything, if it goes to court of appeal, more than 8 years. Right? More than 8, but you know, in order to get an, you know, the date to, you know, I mean, the hearing date from the, I mean, in order to, you know, the Supreme Court also appeal procedure, appeal to the Supreme Court, and to take a, you know, date for the hearing takes more than 3 years. ලංකාවේ නඩු කීයක් තියෙනවා? Supreme Court, you know, you against the award, you can go to court of appeal. How many years court of appeal will take? and then the, say for example, Court of Appeal affirms the decision or award is, accepted. Then against that decision, sometimes the employer goes to Court of Appeal. Sorry, Supreme Court. Supreme Court takes another 3-5 years, 4-5 years. So entire period, maybe more than 8 years. එහෙනම් නෙමෙයි ඒකට ගිහිල්ලා අපීල් කරන්න අපීල් කරාට වැඩක් නැහැ නේ. ඒක රෙජිස්ටර් කරලා කේස් එක ඕකේ කරන්න ඒකටම යනවා අවුරුදු දෙකකට. ලංකාවේ නඩු මේ ලේබර් ලෝ එකේ නඩු මේ LTA එකේ අහන්නේ. ලේබර් ලෝ එකට අදාළ ටර්මිනේෂන් පොඩි කැලි ටිකක් විතරයි. දැන් ඕක නිසාම අනිකුත් නඩුත් LTA එකට දාන්න කියලා 50ක් ඇමෙන් කරා. උනට වෙන්නේ නැහැ ඒක. හරිද? යන්නේ මොකද්ද? Court of Appeal, Magistrate Court, Court of Appeal, Provincial High Court, Supreme Court මේකනේ යන්නේ. මේ ලේබර් නඩු විතරද තියෙන්නේ? ලංකාවේ. Court of Appeal එකට, Supreme Court එකට මේ ලේබර් නඩු විතරද තියෙන්නේ ලංකාවේ? මේවා insignificant. අනිත් ඒවාත් එක්ක. So it takes more than 8 years. So say for example, award is granted by labor tribunal. So termination of employment, for example. I කියලා ගන්න ඉන්නේ නැහැ පණිනවනේ. So therefore, employers are trying to drag, right? Drag. When it comes to the involvement of money, back wages or terminal benefits, right? Compensation. So say for example, the strike has taken place. Oh, sorry, not the strike. So due to trade union action or whatever, an employer terminates 10 people. Hey, 10 people. For example, instead of going to LTE them, right? Because more than 15 employers, so they approach to the labor department. Labor department try to conciliate, but wait, right? The matter will be, but that is separate case. Say for example, because termination is illegal, right? The commissioner can order, right? Not to refer for, those matters are not termination. Sorry, termination also comes under the what you call industrial dispute. Say okay, right? Without going for LT, they come to the labor department, right? Because they have not termination. They have not gone to the labor tribunal before 6 months from the date of termination. After that, 6 months ගියොත් ඒ කියන්න බෑ. approach කරනවා කියලා හිතන්න මේ labor department. labor department එකට section 2 එකකට order එකක් දෙන්නත් බෑ. එතකොට මොකද කරන්නේ? ඒක conciliate කරනවා. So conciliation fails and refer for arbitration. Right? Arbitration or industrial court. So industrial court or arbitrator says, award says 1 million for each. Say for example, right? 1 million for each. Then 10 workers, 10 million. Right? Has to be paid. That is an order, for example. Okay? So what is the remedy if employer disagree? The employer can go to court of against the award. Say, employer, so Court of Appeal dismiss the application. It means that the employer is supposed to adhere to the award. And again, that decision, employer goes to Court of Appeal. So sorry, Supreme Court. When the case is finalized, more than 10 years, more than 8 years altogether. So after today 1 million, After 10 years, what is the value? What is the value with the inflation? The value of money declined. So that is why this amendment was brought in 2022. If employer wishes to go to Court of Appeal and Supreme Court, whatever, what not, the money, or whatever, the amount awarded by an arbitrator or industrial court must be deposited before go to Court of Appeal with the Commissioner General of Labor. That money will be deposited in a separate account. It will attract annual interest rate. Will attract annual interest rate. So after maybe 8 years, go to Supreme Court, and after 8 years, Supreme Court dismiss the application. It means that the employer has to adhere to the oath. Now the money is there with interest. So the 10 people, as example, they will get 1 million plus interest rate for the years. 8 years, if it is 8 years or 10 years. So that is why, value of money will decline because employers are trying to drag this. Then the workers will be negatively affected. That is why, okay, you have right to go to Court of Appeal and Supreme Court, but before you go, deposit this money with the Commissioner General of Labor. Otherwise, your application and the Court of Appeal will not be accepted. Okay? Is it clear? Deposit with the Commissioner General. The Commissioner General definitely must deposit in a government state bank. Government cannot open account. Government institutions cannot open account in private commercial bank. No. Only BOC, People's and NSP. Mostly People's and bankruptcy. The NILs, NILs and statutory bodies, they, if they have excess money, they can deposit, right? Whatever the bank, higher interest rate is support. But no government departments, government ministries cannot open account in private, right? So it will mainly people's, right, deposit. So the Labor Department has taken permission from the Treasury to open some separate account because Mama might so separate account, and then the money will be put in that separate. No one can touch until the case is finalized. Okay, it is under the custody of the Commissioner General of Labor. Okay, is it clear? Yes. Oh. මොකටද ඉන්ට්‍රස්ට් එක දෙන්න නැත්නම් මොකටද මේ 50 පැමින් කරලා හොයාගත්තේ? right. එයාට අවාසියක් වෙන හින්දානේ. ඒකට එයාගේ මුදලයි ඒකට අවුරුදු 5 ලැබිච්ච පොලියයි එකතුව එයාට දෙන්න ඕනේ. මම ඒකත් එක්ක මේකට අනාගතේ දැන් ඉස්සරහ ලේබර් වල දැන් අපිට ඉන්ටර්වියු කියනවා. එතකොට දැන් දානවනේ කේස් ඊට පස්සේ මේකෙන් කියනවා ගෙවන්න. එතකොට ඉල්ලනවා ඉන්ස්ටෝල්මන්ට් ප්ලෑන් එකක් කරන්න. එතකොට ඉන්ස්ටෝල්මන්ට් වයිස් ඩිපොසිට් කරන්න. කොහොමද එම්ප්ලොයර් account එකේ ඔක පෙන්නන්නේ නැහැ. එතකොට දැන් ඕක මේවා කරලා ෆයිනලි මේ ටෝටල් ඩිපොසිට් කරලා ඉවරනාට පස්සේ කරන්නේ. එතකොට හැබැයි ඉන්ස්ටෝල්මන්ට් අර ඉන්ට්‍රස්ට් එක නැතිවෙ හම්බෙන්නේ නැහැ. මම when you are, if employer is in a serious financial difficulty, maximum 36, by looking at the situation, maximum installment 36 installment will be granted by the commission. So when you pay the, what do you call this, installment, now, not previous, it's very difficult, but now, when you pay the installment, right? So, the proportionately, the money will be debited into individual account by the central bank. Okay. So then somehow you capture little bit of interest. Okay. Then again installment එක ගියාම proportionately again සේවකයන්ගේ පඩිය විස්තර දෙන්න බෑ. හරිද? එතකොට ඒකේ අනකොට එයාගේ පඩිය කීයද ඒ අයට කියන්නේ installment එක දුන්නාම ඒක proportionately එයාගේ salary එක ගන්නවා individual account එකට යනවා. සමහර වෙලාවට මෙහෙම. ඔක dormant account එකක තියෙනවා. හරිද? dormant account එකේ තියලා අන්තිමට ඔක්කොම ගෙවලි උරුණාට පස්සේ right එතකොට interest එක dormant account එකේ තිබ්බත් එකතු වෙනවා interest එක. හරි. ඒක එනවා. right industrial amendment මේ amendment එක කරේ අන්න ඔය හින්දා. right well so application for reconsider of award of an industrial code. I discussed this one, right? Section 27. Any party, trade union, employer or workman bound by the award of an industrial code who desires that such award be set aside or replaced by a new award, or that the terms and conditions be modified, or that any new terms or conditions be inserted in the award, may make application in that behalf to the minister, and the minister shall, right, thereupon refer the application if minister is okay, right? Appeals, it has to be done. Appeals for consideration by an industrial court, another industrial court. So before 12 months after award came into force, පළවෙනි award එක බලාත්මක වෙච්ච දවසේ ඉඳලා මොකද වෙන්න ඕනේ? ඒ කියන්නේ 12 months, right? ඇතුළත ඒක කරන්න ඕන. Before 12 months after award came into force, right? Right. Duties and powers of industrial code in relation to application under section 27. Again, appeal කරන එක මේ කියන්නේ. 27 වල කියන්නේ මොකද්ද? Appeal procedure to the minister to reconsider the award. So section 28(1), an industrial code to which an application under section 27 in relation to any award is referred may in its decision. It means duties, 27 එකේ යටතේ application එක ආවොත් මොකද කරන්නේ? මේ appeal එක ආවොත් නන්ද මිනිස්ටර්ට පුළුවන් නන්ද ඉන්ඩස්ට්‍රියල් කෝට් එකක් පත් කරන්න. ඒක පත් කරාම එයාලට මොකද කරන්න පුළුවන්? affirm the award, කලින් award එක affirm කරන්න පුළුවන්. set aside the award, අයින් කරන්න පුළුවන්. ඒක පැත්තකට දාන්න. set aside the award and make a new award in place thereof, or vary or modify the award in such manner as may appear necessary. ඒක කලින් එක affirm කරන්න පුළුවන්. මම කලින් එක සම්පූර්ණයෙන් අයින් කරලා වෙනම එකක් දෙන්න පුළුවන්. වෙනම award එක. එහෙම නැත්නම් කලින් එකට modification එකතු කරන්න පුළුවන්. Okay? ඒ appeal එකේ අර. Right. Thus the minister has power to refer industrial dispute which is being investigated at LT for an arbitrator. නඩු තීන්දුවක් තියෙනවා. Right? This is I'm not going to read this. I will tell you the exact result instead of reading this one. So, what is the question? Does the minister has power to refer industrial dispute which is being investigated at the LT for an arbitrator? Minister to පුළුවන් ද LT එකේ ඒ කියන්නේ LT යන්නේ කොහොමත් මේ termination LT එකේ දැනට විභාග වෙමින් තියෙන industrial dispute එකක් එහෙට ගිහිල්ලා සේවකයා මෙහෙට ඇවිල්ලා පැමිණිල්ලක් දාන්න. මිනිස්ටර්ට පුළුවන් ද මේක ආර්බිට්‍රේටර් කෙනෙකුට දාන්න.
ගානවා කියන්නේම ඉතින් ඉතිස්සල්ලා ඒක කමිෂන් ආරහා එක්ක ඒක. ඒ කියන්නේ සේෆ් ටයිම්
ඔව් හිතන්නකෝ LT ලේබර් ඩිපාර්ට්මන්ට් එක මුකුත් බලන්නේ නැතුව රයිට් සමහර වෙලාවට එන්නෙත් නැහැ වෙන්න පුළුවන් පාටිස් දෙක කියන්නේ නැහැ මෙයා LT ගියා කියලා. so then මේකට රිපෝට් කරනවා මිනිස්ටර්. එම පුළුවන්ද? the answer is no. Right? If matter is being heard by an arbitrator or industrial court, LT has no jurisdiction to take up that matter. On the other side, if matter is being heard at LT, minister or labor authority has no power to refer the same matter for arbitration.
sir. Excuse me.
Yes.
ඔය ඒක කියන්නේ සර් එක සබ්ජෙක්ට් එක නඩු තුනක් දානවා වගේනේ ඒක. ඒ නිසා වෙන්න ඇති.
එකම සබ්ජෙක්ට් එකට නඩු දෙකක් දාන්න දෙපොලක කතා කරන්න බෑ. The one subject, same subject cannot be discussed at two places. Is it clear? පැහැදිලිද? ඉස්සෙල්ලා ගියේ LT එකට නම් the first instance before say for example the person first go to LT and made an application. It is being heard. And the same person comes to for the same matter and the lodge a complaint with the labor department. It is the duty of the labor department before investigating. Make sure that the person has not gone to LT. It is the duty of the labor department. Right? Is it clear? At the same time, if matter is being or has been referred for an arbitrator, then arbitrator is, the matter is being heard by an arbitrator or industrial court. For the same matter, worker goes to LT and make an application. So LT has no jurisdiction to intervene into that matter because it is already being heard by an arbitrator or industrial court. Right? The judgment, Upali Newspapers Limited versus Exat Kamkaru Samithya and others. So arbitrator so section which would enable him to refer dispute which is pending before a labor tribunal to an arbitrator for settlement is incorrect. Right? A contrary interpretation would necessarily, right, bring the and violate the principle of independence of the judiciary enshrined in Article 116 of the Constitution, which is the paramount law. The Constitution. Right. So next, you can raise any question, huh? Oh, is a LT president a judicial officer? Again, Upali Newspapers Limited is the Article 170 of the Constitution. Read with Article 114 shows that the president of labor tribunal is included in the definition of judicial officer. දැන් තමයි මේ කියන්නේ. කලින් තිබුණේ නැහැ. කවුද කියන්නේ? මම නෙමෙයි. ඒ කියන්නේ LT president දැන් කවුද යා? Why we are saying judicial? Because previously not lawyers they were LT president was just administrator. Now they are appointed by the Judicial Service Commission. They are titled as, in addition to the LT president, they are additional magistrates. Additional magistrates.
So excuse me.
Right. The court has interpreted they are, judicial officers.
So excuse me.
Yes.
So any decision given by the president is binding.
Sorry.
එයාගේ decision එක binding ද sir? Binding effect එකක් තියනවාද? judicial officer nang. Lagi
Why,
ko.
why
Huh?
not? Why not? You know, once LT is given what? LT is giving what? Orders.
Orders.
Orders are bound by the parties. And even awards are bound by the parties. Right? But they have remedy, you know, if they do not agree, then there is a remedy for them against LT decision. They have to go to either adhere to the order or go to what? Where? Provincial High Court against the order. The courts granted
Yes,
by
yeah.
an arbitrator and industrial court. Parties are bound by the word. They have to adhere. If not, if against, then they have to go to court of appeal against the award. Okay, Ahmed, is it clear?
Yes, sir. Yes.
Does the minister has power to refer industrial disputes which is being intricated at LT? I said no. Right. Minister has no. Again, you know, one another in 2020, the Hong Kong and Shanghai Banking Corporation Limited versus WDJ Shanghai. මේකේදී උනේ එතකොට මෙයා තමයි මිනිස්ටර්. I was the Commissioner General of Labour. Like මේ case එක එනකොට. So before, you know, before my tenure, you know, it has been referred for the minister back, you know, couple of years back. I mean, under my predecessor. So then, without looking at, you know, the LT and everything, matter has been referred for the minister to appoint an arbitrator and the matter for arbitrator. The case already been heard at the LT. So now there is in this regard already case is finished, right?
So, Supreme Court also.
Yes, may ළඟදී ආවේ.
What was the case?
මෙහෙමයි LT යන්නේ Okay. Sorry, couple of others. එක්සත් කම්කරු සමිතිය trade union. HSBC case, one employee, but on behalf of the employee, application was made by the trade union. Should there be a live dispute when referring to an arbitrator? Arbitrator කෙනෙකුට refer කරනකොට live dispute එකක් තියෙන්න ඕනද? Live dispute එකක් තියෙන්න ඕනද? Should there be a live dispute when referring matter is referred for an arbitrator? The Mercantile Investment Limited versus Sumit Adihetti Supreme Court appeal case, right? 2016 decided. Look at the case at the Supreme Court 2012. Before Supreme Court, Court of Appeal. We don't know how many years. Here, almost 4 years. The case was filed in 2012. Decision was given 2016. Oh, what if? It is obvious that when an award is made, the terms of the award becomes implied terms, right, attached to the contract of employment. So, there should be an existing contract of employment for the award to take effect at the time of making the award at the end of the arbitration. Say, for example, the promotion is not being given. That is the case. Dispute. Okay. Your promotion has not been done. You are demanding promotion. And that becomes, you know, there is a difference between employer says, no, you're not entitled. You say, I'm entitled. So it's a dispute. You lodge a complaint with the labor department. And amicably cannot be settled through conciliation. The matter will be referred for an arbitrator. During this period, before award is granted, you resign and join some other company. You resign and join some other company. Then, is there a live dispute at the award is granted? No. If you still, there with the company, then there is, employer, you have not breached the contract of employment. If you breach the contract of employment before award is granted, then there is no live dispute. Okay?
So at the time of hearing the thing at the arbitrator,
Yes.
let's say, because they are at that time, but later on, it turned to put up then into Supreme Court. By that time, he had.
By that time, see,
Yeah.
yeah. But until the award is granted,
What is granted at the fifth level. So
award is always granted by an arbitrator or industrial court, right? Magistrate court, no award. Those are orders. Supreme Court, Court of Appeal, no award. Award comes into picture under the Industrial Dispute Act only. Arbitrator and industrial court. Well, ප්‍රශ්නයක් නැහැ ඒක ප්‍රශ්නයක්. ඒ කේස් එකේ ඉතින් එතකොට අවෝඩ් එකට ඇඩ්ඩිය වෙන්න එපා. ඇඩ්ඩිය නොවි හිටියොත් ලේබර් ඩිපාර්ට්මන්ට් එක ලයිව් ඩිස්පියුට් එකක් තියෙන්න ඕන අවෝඩ් එක දෙන තෙක් විතරයි. හරි.
that case, I know this person.
ආ
Anything direct.
ස්මිත්
No,
Sumit.
no. Adhihet.
ආදිහෙත්
So then he joined, I think, another famous finance company.
Hmm.
I think
this
he retired recently, if I'm not mistaken. So probably joined another
company after award is granted.
Probably before. No? That's why.
No, because here, look at that. And the award at the end of the arbitration, this section, right, presuppose the existence of a valid contract between the employee and the employer.
So here, the thing is, he has joined another company because of that he didn't get it.
Look, it is obvious that, I don't know whether he has joined some other company, but right, it is obvious that when an award is made, award එක දෙන වෙලාවට, the terms of the award becomes implied terms attached to the contract of employment. Right? So there should be an existing contract of employment for the award to take effect at the time of making the award at the end of the arbitration. Right? It means that the person has left the place. Right? This, we have to read entirety. We can't, make a judgment on based on that, right? So if person has left the place, joined another company before award is granted by an arbitrator, there is no live dispute. කියන්න බෑ මට මේ ආර්බිට්‍රේට් award එකේ තියෙනවා contract of employment එකේ තියෙනවා කියලා කියන්න බෑ. implied terms කියලා කියන්න බෑ. අය මිනිහා නෑ මෙතන. හැබැයි award එක දුන්නට පස්සේ නෑ යන්නේ. එතකොට valid. Right. Okay, well. Look at now. Look at now this. Right? Look at now. I find that there was a live dispute to be gone into from the date of the transfer to the time and date on which the applicant joined another company, because the applicant could be registered, regarded as an employee who wanted to resolve that dispute, having resorted to the provisions of the Industrial Dispute Act. Again, I find that there was a live dispute to be gone into from the date of transfer to the time and date on which the applicant join another company. What does it mean? Because the applicant could be regarded as an employee who wanted to resolve that dispute having resorted to the provisions of the Industrial Dispute Act. මොකක්ද කියන්නේ? මේ මිනිස්සයා ඉන්න වෙලාවට dispute එකක් තිබිලා තියෙනවා කියලා මේක කියන්නේ. හරිද? ඒ කියන්නේ මෙයා join වෙලා තියෙන්නේ dispute එකේ award එකට පස්සේ. right? පස්සේ වුණාට පස්සේ නම් entitled නේ. entitled දෙන්නේ නැහැ entitlement එක කවුද? mercantile මේ mercantile investment එක. දෙන්නේ නැති හින්දානේ මේක යන්නේ. right? දෙන්නේ නැති හින්දානේ මේක යන්නේ. කවුද? mercantile investment ආදිහෙත් Supreme Court. දැන් ඒ කියන්නේ මේක තව තියෙන්නේ නැති Supreme Court යන්නේ නැත්තේ මේ award එකට against නේ. ෆොටෝ පැපිල් යන්නේ නැති. ෆොටෝ පැපිල් එක අප්‍රූව් කරන්නේ නැති. right award එක. ඊට පස්සේ Supreme Court ගියා. Supreme Court එකෙන් සෙටසයිඩ් කරා. කියන්නේ එයා ගිහිල්ලා තියෙන්නේ අනිවාර්යයෙන්ම එතකොට award එක දුන්නට පස්සේ. join කරා. well, what powers do the Labour Commissioner and the Minister have when directed matters for arbitration? Just be very quick. Does the Minister have power to recall it after dispute has been referred for an arbitrator? Arbitrator to refer කරපු එක නැවත කැඳවන්න පුළුවන්. පුළුවන්. Once matter is referred for an arbitrator, has the minister power to recall it? No. The simple answer, very straightforward answer is no. But once matter is referred for an arbitrator, the arbitrator is appointed. Arbitrator can resign. Arbitrator can resign. Resign in the sense decline. Giving some reasons due to his personal or some other reasons, he is I'm not in a position to accept this one, right? Please excuse me or something like that. Then minister can appoint. අපි ඒක කරා. අපි ඒක කරා. කියන්නේ එයාට කියලා ගත්තා.
ඒක වෙලාවට ඇක්සෙප්ට් කරලා දීපේ.
නෑ අපි කිව්වෝ ඒක පරිදිම පුදුම දැනෙනවා කරන්නේ. දන්න කෙනෙකුට දාලා ඒක උනේ දන්න කෙනෙක් කියන්නේ. we can convince. එහෙම නැතුව අපි කේස් දෙන්නේ නැහැ නේ අපෝ. ඒක නිසා මේ ඒක කරා. Right. There is no provision in the Industrial Dispute Act for substituting parties to an industrial dispute referred to an arbitrator. Following, may case again. No, minister does not have that power. Right. What is just and equitable award? What is just and equitable award? Right now. What is just and equitable award? The earliest interpretation of just and equitable by S.T. Pranandu Justice in Richard Peary's Company Limited and Company Limited versus, right, Vijay Sirivardan, earliest one, 1900 had taken. Yeah. Where the expressed the view that just and equity can themselves be measured not according to the right urgings of a kind heart, but only within the framework of the law. මම translation එකකුත් දාලා තියෙනවා. යුක්තිය සහ සාධාරණත්වයේ යන ඒවා මැනිය හැක්කේ කරුණාවන්ත හදවතක ආසාවන් අනුව නොව නීතිය නම් වූ රාමුව තුළ පමණකි. Earliest one, right? Justice and equity can themselves be measured not according to the urgings of a kind heart, but only within the framework of the law. Well, what is just in Cell Company of Ceylon versus right? Patiran 1963, right? Abhay Sundar, Justice Abhay Sundar held that the power to grant relief is only limited by the duty to make a just and equitable order, which is wide enough to grant relief, notwithstanding anything to the contrary in any contract of service. Contract of service ඒවා මෙතනදී සලකනවාද? So look at, which is wide enough to grant relief, notwithstanding නොසලකාරේ anything to the contrary in any contract of service. Grant relief ඕනවට වඩා හිතන්න එපා සමහර ඒවා මේ ලෝ එක ගත්තාම කියන්නේ නීතිමය කරුණු පැහැදිලි කරන විදිහයි අපි වටහා ගන්න විදිහයි දෙකක්. හරි. ජජ්මන්ට් හරි ප්‍රවේශමෙන් කියව ගන්න. නැත්නම් වෙන අදහසක් අපේ හිතට එන්න පුළුවන්. Let us go to latest one. Again, right, the same thing, the Supreme Court rejected the argument that just and equitable relief could be given contrary to statute. The powers of these courts are also limited by the statute that, right, created them. Again, statute can නීතියට පිටින් අපිට යන්න පුළුවන්ද? බෑ. Again, municipal council, this is very famous. Versus Munasingha, 19, again, when the Industrial Dispute Act confers on an arbitrator the discretion to make an award which is just and just and equitable, the legislature did not intend to confer on an arbitrator the freedom of a wild horse. Again, අදහස් කරන්නේ මේ. Wow. කැලෑ අස්වැයෙකුට වගේ يعني නිදහසක් තියෙන්න බෑ කාටද? ආබිට්‍රේට්. එහෙම ඕන විදියට දෙන්න බෑ. ඒකයි මේ කියන්නේ. කැලෑ අස්වැයෙකුගේ නිදහසක් ඒ කියන්නේ ෆ්‍රීඩම් එකක් තියෙන්න බෑ. එයා නීතිමය රාමුවෙන් මොකද වෙන්නේ? කොටු වෙනවා. ඒ just and equity principle කියලා follow කරනවා කියලා හිතෙන දේවල් දෙන්න බෑ. The mandate which the arbitrator in an industrial dispute holds under the law requires him to make an award which is just and equitable and not necessarily an award which is favors an employee. So in the back, an arbitrator holds no license from the legislature to make such an award as he may please, for nothing is not just and equitable which is decided by him or right caprice or by the toss of a double-headed coin. Again, අර toss එකක් දානවා වගේ එහෙම කරන්න බෑ. ඒක by and chance නේ. by chance. toss එකක් දානවා වගේ just and equity කියන්නේ ඒක නෙමෙයි. Right. This is in another one. In making of a just and equitable order, one must consider not only the interest of the employees, but also the interest of the employers and the wide interest of the country. For the object of the social legislation is to have not only right contented employees, but also contented employers. Both parties. These are not rocket science, you can understand. So this is important. Guidelines to follow when making just and equitable award. An order based on case law. Why order? Why order? LT gives an order. LT also must follow just and equity principle. Follow the natural justice as well. So, based on case law, Municipal Council of Colombo versus Polsingo, which I shared with you now, Associated Cables Limited versus Kalmatarange, Suryarachi versus, I don't know, I can't. Bavarian or Reef Hotel. So, based on these judgments, we have prepared guidelines when just and equity principle is followed. These are the guidelines. The law of the land should be followed. රටේ නීතිය පිළිපදින්න ඕනේ. The tribunals and arbitrators should act judicially by following the principle of natural law. It means hear the both parties and no one hear his own case. තමාගේ නඩුවේ තමා දෙපාර්ශ්වයට හුම්කම් දිය යුතුය. තමාගේ නඩුවේ තමා විනිශ්චයකාරයෙකු නොවේ. කියන්නේ පක්ෂග්‍රාහී වෙන්න එපා. Right. All materials evidence should be considered. Sielu material to be considered. Orders or awards should contain reasons therefore. Therefore. Reasons then. මේ ඕඩ් එක දෙන්න මෙන්න මේ කරුණු පදනම්. Order එක. The tribunals and arbitrators must not act arbitrarily. Okay, any question so far?
You're an arbitrator connector, so in the 3 months
එහෙමයි. ආබිට්‍රේටර් කෙනෙකුට අපි ඩිමාන්ඩ්ස් වලින් ඒ කියන්නේ arbitrator once you refer an industrial dispute for an arbitrator, right, for the settlement and give an award, you can't take it back. Even though 100 goes, 100 years, you cannot recall it because there is no provision in the Industrial Dispute Act to recall it. Amendona. මොකද නැත්තේ? අලුත් in the drafted, industrial again, right? Maximum 2 months to 3 months. Otherwise, minister has power to, or commissioner has power to recall it. Okay, well,
excuse me.
yes.
ඩිස්පියුට් එකක් ආවම ඉස්සෙල්ලාම යන්න ඕනේ අපිට ස්ට්‍රේට් අවේ ආබිට්‍රේටර් ගාවට යන්න පුළුවන්ද නැත්නම් LT ගිහලාද යන්න ඕනේ?
ආගෙන හිටියේ නැද්ද? ආමන් මන් repeatedly පුන කිව්වා jump කරන්න බෑ, right? procedure එක follow කරන්න ඕනේ. මුලින්ම බලන්න ඕනේ මේම එහෙම බෑ කියලා කොහෙවත් නැහැ. එහෙම දාන්න නැහැ. right? බෑ කියලා කොහෙවත් නැහැ. හැබැයි conciliation එක කරලා ඊට පස්සේ තමයි පේල්ුණොත් ඊළඟ step එක තමයි ආදිතේ. Normally once matter is referred for, industrial dispute received by the Labor Department, what the Labor Department does is the conciliate, right? First step is conciliate. If conciliation fails, then, matter will be referred for an arbitrator. Sometimes, for example, if there is a major dispute in the country, which affects, significant number of workers and the economy as well, sectoral or any other sector in the economy, then that matter will not be conciliated by the labor officer or assistant commissioner. It will be taken up at the head office level by the commissioner industrial relations to conciliate. At once or twice, maybe at once. And then commissioner industrial relation fail, matter will be referred for the commissioner general. Commissioner general may, summon them at once. Right? Sometimes 4 hours, 5 hours, discuss. If there is no amicable solution, the following day, matter will be referred for an arbitration. Is it clear, Ahmed?
yes sir, yes.
Okay, right.
So මම තව එකක් ඇහුවේ ඇයි දන්නවද මේ අර පාර්ට්නර්ෂිප් ඇග්‍රීමන්ට් වල අපි දානවනේ ඩිස්පියුට් එකක් ආවොත් අපි ආබිට්‍රේටර් වලට යොමු වෙනවා කියලා. ඒ වගේ කන්ට්‍රැක්ට් එම්ප්ලොයිමන්ට් එකේ දාන්න පුළුවන්ද අපි මොනවා ඩිස්පියුට් එකක් ආවොත් අපි කෙලින්ම ආබිට්‍රේටර් ගාවට තමයි රිෆර් කරන්නේ LT යන්න බෑ කියලා දාන්න පුළුවන්ද?
Back. You are violating the law.
ආ.
You are violating the law. Because if dispute arises, you can have agreement with the trade union. Say, for example, if you have collective agreement, such collective agreement may contain the provisions how to settle industrial dispute at the industry level. or,
Okay.
or plant level or whatever, right? Company level. Otherwise, you are not supposed to put such conditions in the letter of appointment or whatever it is, right? You can't have.
Mm.
So because the very clear provisions are there in the industrial dispute. Yes, you can settle at the organizational level if you have collective agreement or any other agreement, right, with the trade union, how to settle industrial dispute.
Mm.
Okay. Otherwise, no, you can't violate the law. Right? Okay. In delivering a just and equitable decision, the powers of the boards have been limited by judicial decisions in Sri Lanka. Boards කියලා මෙතන කියලා කියන්නේ arbitrator board එකක් හෝ නැත්නම් industrial court. Accordingly, the facts to be considered in giving a fair and just ruling are the law of the country must be followed. I have discussed these things, right? Repeated. Does an arbitrator, right, gain the authority to provide relief to other employees based on a wrongful payment made to an employee? What is this? Ceylon Petroleum Storages Terminal Limited versus BK Prabhat Chandrakirti. During my tenure, this case was filed, but the decision came, during my successor, right? But former one. So what is this? Whilst it was an admitted fact among all parties that the special allowance paid to 2 employees created an anomaly, and also in the backdrop that the petitioner at any stage during the arbitration proceeding had not attempted to justify such anomaly, it is, right, pertinent to find the legal basis upon which the arbitrator has given, right, light to a suspended payment that was made, right, erroneously. I see no valid reason for making an award in favor of the respondent based on an unjust enrichment of 2 employees of the petitioner company. මොකද්ද මේ කියන්නේ? දෙන්නෙකුට වැරදි විදියට ගෙවලා. හරිද? ඒ කියන්නේ ස්පෙෂල් allowance එකක් ගෙවලා තියෙනවා. Employee created an anomaly. ඊට පස්සේ මොකද කරේ? දැන් මෙතන කියන්නේ does an arbitrator gain the authority to provide relief to other employees based on a wrongful payment? වැරදි ගෙවීමක් කළා තියෙනවා. කාටද? සේවකයෝ දෙන්නේ. ඊට පස්සේ anomaly එකක් ආවා. Anomaly was created. The affected party, those who do not get, they complain to the labor department. The matter referred to an arbitrator. Arbitrator awarded to extend or grant those 2, whatever the increment, to other workers as well. අනිත් අයටත් මේක දෙන්න කියලා award එක දුන්නා. අර දෙන්න. But it was a wrongful. Then the company went to where? The court of appeal. Court of appeal. So I see no valid reason for making an award in favor of the respondent based on an unjust enrichment of 2 employees of the petitioner company. එනිසා award එකක් දෙනකොටත් අවට ගියාට ඒ කියන්නේ මෙහෙම එකක් තියෙනවා. කෙනෙක්, remember that if you have received something which is not entitled to you, right? මේක රාජ්‍ය සේවයේ තියෙනවා. If something you receive which is not entitled to you, right? The employer has right to get it back. දැන් රාජ්‍ය සේවයේ වැරදිලා වැරදි ස්කේල් එකක තියලා පඩි නියෝස් එකේ වැරදි ස්කේල් එකක තිබිලා ඒක වරද්දලා මිනිස්සු අපොයින්ට්මන්ට් එක දෙනකොටම වරද්දලා වැරදි ස්කේල් එකක තියලා අහුවෙන්නේ අවුරුදු ගාණක් ගියාට පස්සේ රයිට් මම හිතන්නේ ලක්ෂ 4-5 ගෙවන්න ඊට වැඩි වෙන්නේ so so we revert it back right මම ඉතින් අවුරුදු 5කින් ගෙවන්න දුන්නා මොකද සාධාරණයි කියලා හිතලා secretary has the power to determine it ඉතින් මම 5කින් කපා ගන්න දුන්නා so මේකෙදි මොකද ආවිතේට කරලා තියෙන්නේ වැරදි විදිහේ ඉවීමක් කරලා තියෙනවා ඒකෙන් අගතියටපත් ආයේ මොකද කරන්නේ අපිටත් ඒක ඕනේ කියලා ඉබ ඩිපාර්ට්මන්ට් එකට ආවා ආවිතේට කිව්වා නෑ දෙන්න ඕනේ but at the court of appeal it was argued that it was wrongful payment right නෑ ඒක කියන්නේ නෑනේ මෙතන ඒක නෙමෙයි dispute එක you have to understand the dispute is I have been paid wrongfully increment you and other people right and created animal we were at the same boat right same platform and you lodged the complaint with the labor department right the arbitrator has no right to make an award say something whether I have been paid wrongfully or not that is something else arbitrator cannot say that the employer should recover the money the wrongful payment arbitrator cannot say because the dispute is due something else
Yeah, but of the example that you put up.
Yeah.
Now that can be unfair from the point of view of the employee because now he might not know at the salary level that he's based at no. So he's being given something in the appointment letter. He's being given something, but he doesn't know whether this is outside he's getting a.
But when it comes to law, there is an argument, right? You can argue, but remember that if you are not entitled for something, right, you are not entitled, right? Whether sometimes it may happen, right, without your knowledge, right? Without your knowledge. So immediately, what the employer can do once it is the realized, it can be stopped, right? You cannot go to, you can, but you can't argue that it's your entitlement. You can't argue that it is, acquired right. No.
Under unfair labor practices.
Unfair labor practices, unfair labor practices is something else. Unfair labor practices, if as the employer, you are engaged in, trade union activity, I transfer you. I demotivate you. That is unfair labor practice. Right?
So what I'm saying is now, person there is no way for that person to know what would be the internal structure of the payment.
Yeah.
Right? So when he joins, he's been given, let's say, actually he should get 50 for his grade, but in the appointment letter they made a mistaken, 100,000 was given. But he doesn't know that because he's joining as a pressure to this organization.
No, because if don't misunderstand, right? When it comes to private sector, if appointment letter says the salary structure, it has to be paid, right? This is something else, right? This is something else, not this is an increment. 2 increments has been given only for 2 people. Right? Wrongful increment. Wrongful increment. By mistake, whatever it is. But if your appointment letter says something, the salary, you cannot say that. But when it comes to government, comes to government organization, there is a salary structure in the, what you call TOR, the terms of reference, right? Scheme of recruitment. Salary structure එක තියෙනවා. ඒක වරද්දලා ගෙවුවොත් ඒක අය කරගන්න පුළුවන්. අතෙන්දී ඕ වෙලාවට අය කරගන්න it can be stopped when it comes to private sector. If something wrongfully has been paid, right? It can be stopped, right? The employer cannot argue that, no, it is my right. No, you can't. Because you are not entitled. Don't misunderstand. I'm not referring to, the salary scale stipulated in your letter of appointment. I'm not referring to that one. By mistake, because you have accepted and the salary scale, it has to be paid. But during, memo yanagoda, ataraduredi, why we say whatever, wrongful termination. What is the principle? What you need to understand this one, whether it is correct or not. Arbitrator, because the arbitrator has ordered or not awarded to pay this increment to other workers as well. He must, if when it award, award just and equitable award, when the arbitrator make just and equitable award, he must consider all these things. That is just and not only to the employee but also to the employer. The employer must prove that employer might have given all information to prove that this is a wrongful increment. Otherwise, at the order of appeal, it cannot be proved. Okay.
bonus වගේ.
ආ.
bonus එකක් දෙනවා.
ඔව්.
ඒ
ඔව්.
bonus එක calculate කරන විදිය
ඒක පුළුවන් ඉතින්
performance based කියන එක.
ඔව්.
හරි. ඒකට ඒක rating එකයි ගොඩක් factor දෙනවනේ. එතකොට ඒ ආවට පස්සේ ඒ ඉන දාන හිට යන දෙනවා 500,000 bonus. 500,000 bonus එක calculate කරපු විදිය employee ට කියන්නේ නැහැ. ඉතින් bonus කියලා නේද? ඊට පස්සේ HR එකෙන් identify කරනවා වැරදිලා තමයි අපි calculation එක මෙයාට 400,000 යන්න ඕනේ. 500,000 නෙමෙයි. ඒ 100,000 recover කරගන්න පුළුවන්.
මේවා recover කරගන්න පුළුවන්. එයාගේ පඩින් අඩු කරන්න බෑ. right? පඩින් අඩු කරන්න මොකෙන්ද recover කරන්නේ?
ඉස්සරහට දෙන එකකින් අඩු ගන්න.
ඉස්සරහට දෙන එකකින් අඩු කරන්න පුළුවන්, but he has employer ට ඒක බෑ කියලා කොහෙවත් නැහැ. හැබැයි ඒ මිනිහා complain කරොත් dispute එක. හරි? dispute එක amicable settle කරගන්න පුළුවන් වෙන්න පුළුවන්. නැත්නම් arbitrator ගාවදී අරුණු කියලා award එක ගන්න ඕනේ in favor of employer. අවුල් නැහැ. increment දෙන්න කියලා කොහොමවත් නැහැ. bonus එකයි increment එකයි කීයද වෙනස? ඉතින් මෙහෙමයි. increment ඒකත් dispute එකක් වෙන්න පුළුවන්. හැබැයි bonus දෙන්න ඕනේ කියලාවත් increment දෙන්න ඕනේ කියලාවත් කොහෙවත් නැහැ. wrongful calculation වලට ගියොත් dispute එකක් එනවා. හරිද? ඒක නෙමෙයි උනේ. ඒකනේ court of appeal එකෙන් ගිහිල්ලා කිව්වේ මේ arbitrator blunder එකක් කළා. arbitrator මේක තිබුණා ඒ වෙලාව මේක wrongful. ඒ නිසා අරගොල්ලන්ටත් මේක අයිති නෑ මේගොල්ලන්ටත් අයිති නෑ කියලා කියන්නේ. But so if there is a contract of employment, then the terms of the award would become implied terms. So if there is no contract of employment, obviously the terms of the award cannot become implied terms. මේක අරකෙමයි මේ මොකේද මේ Pereira versus Standard Chartered and others කියන එකේ නඩු තීන්දුවක් මම වැඩිපුර නඩු තීන්දුව ටිකක් දාලා තියෙනවා. මොකටද? මොකද? බෝනස් එකට ඒක වෙන්නේ එයාත් එක්ක කතා කරලා රිකවර් කරගන්න ඕනේ. හරිද? එයාත් එක්ක කතා කරලා ප්‍රශ්න විසඳ ගන්න ඕනේ. නැත්නම් එයා දෙන්න බෑ කිව්වොත් මොකද වෙන්නේ? දෙන්න බෑ කිව්වොත්. So employer is repushing. Employee is repushing. Right? Repushing. Already and මොකද කරන්න ඕනේ? next bonus එකෙන් අඩු කරන්න ඕනේ. ඉතින් dispute එකක් තමයි ඒක. නැතුව ඒක recover කරගන්න නම් මේ මිනිහා දෙන්නත් මොකද කරන්න වෙන්නේ? යන්න වෙනවනේ district court වලට. ඊළ damage claim කරන්න හැටි ඉතින් යන්න වෙන්නේ. දැන් කරා. ඒක කරදරයි. උනාද? ඒක recover කරගන්න බෑ. think so. What is the possible way? Wait patiently and but give him in writing at the very beginning, right? It has been wrongly calculated. You are entitled for this amount, but please return the amount.
සාමාන්‍යයෙන් කරන්නේ මාත් 12 වෙලා තමයි ගන්න.
Oh,
amount එක අඩු වෙනවා.
අඩු වෙනවනේ. එයාත් එක්ක කතා කරලා ප්‍රශ්න විසඳගන්න තරමට ලේසි නැත්නම් wait, right? අරකින් bonus එක එහෙම නැත්නම් එයාට කියනවා, right, from the next bonus, right, from 12 months you will this amount will be deducted during this period by equivalent amount with 12 months installment, whatever, right? Okay, repudiation and award made by an arbitrator. I told you the Industrial Dispute Act provides that a party bound by an award made by an arbitrator may repudiate the award by a written notice to the commissioner and to the other party. There is no requirement to give any reason for repudiating. However, such repudiation will not have any effect for a minimum period of 12 months from the date of the award. මේක තමයි මම කලින් කිව්වේ. Repudiate කරලා නිකන් ඉන්නවා. Court of appeal යන්නේ නැහැ. You're not, employee is not, either party, not going to court of appeal, but repudiate. Right? Repudiate. ප්‍රතික්ෂේප කරන. adhere වෙන්නේ නැහැ. Repudiate means award is repudiated, not adhering to the award, but against the decision, not going to court of appeal as well. So then the Labor Department immediately has to take action in order to implement the award. Labor Department එක අහකන පියාගෙන හිටියොත් මාස 12ක් යනකම් මොකද වෙන්නේ? මේ මාස 12 කියන්නේ මේකයි. award එක දීපු දවසලා 12 months යනකම් Labor Department employee hari state employer repudiate in writing, inform the commissioner, I'm not in agreeable with the award, may karana award, so therefore I'm not adhering, so I repudiate and inform the other party, and without going to what the court of appeal, wait, by mistake Labor Authority also maybe by the query so not going to the magistrate court to implement what? The order. In order to implement the order, if employer of either party is not going to court of appeal, immediately Labor Department has to go to the magistrate court to implement the order. එහෙම කරන්නේත් නැහැ. මාස 12ක් යනවා. ඊට පස්සේ Labor Department එකට magistrate court එකට යන්න බෑ අර කෝපන් implement කරන්න. ඒ කියන්නේ repudiation එක effect. Is it clear? මාස 12 ගියාන් පස්සේ Labor Department එක and party ගන්න තිබුණානේ. They could have gone to the court of appeal නේ.
But say it's the negligence of the Labor Department. That's it. Well, that's why they are supposed to.
Yeah, they are supposed to. Yes. Negligence of labor. So, after 12 months from the date of award is granted, during that period, either party has repudiated. After 12 months, nothing can be done.
So let's say the employee, the award was in favor of the employee.
Okay, or employee, yes.
Right? So if the department has to file that straightforward. But there is evidence to show that the employee has been following up in writing the Labor Department saying what is happening to this case, why is this not that magistrate court to enforce. But still there's no action has been taken from the Labor Department.
they will know. I mean, it will never happen, right? That is why it is the duty of the employee to inform and, check with the labor department. They will take action. They can't say no, right? It is, they are violating, because then against such officials, the disciplinary action will be taken by the labor department. Otherwise, employee or the employee cannot do it.
This country, anything is possible. No? The employer can actually.
මේමයි මගේ ජීවිත කාලය තුළ මට එහෙම ඉන්ඩස්ට්‍රියල් IR එකේ එහෙම කිසි දෙයක් අහුවෙලා නැහැ. හැබැයි පඩි ගෙවන්න නැතුව ඉතින් 6 years තියෙනවා ඒකට. අවුරුදු 6 තුර නඩුව දාලා නැහැ. රිකවර් කරගන්න බැක් පේජස් වගේ. එහෙම එක කේස් එකක් විතරක් මට අහුවෙලා. එහෙම වෙන්න පුළුවන්. Can be, right? But then, negligence of the labor department, sometimes the parties are affected. Mainly the employees. Employer, they go to, court of appeal, they are more, the strong party. The labor is the weaker party, worker. So it is the duty of the labor department. So, එහෙම වුණොත් ඉතින් අපි ඒගොල්ලන්ට විරුද්ධව disciplinary action ගන්න. එහෙම අරන් තියෙනවා. දන්නන් මත දන්නවා. So, okay. Now I'm winding up for lunch. 12:30. 1:50. Is it okay? 1:50, right? Come back at 1:15. Now time for lunch. Time for lunch. Come back at 1:50.
Okay, sir.
Well, right. Good afternoon, ladies and gentlemen. Let's start the rest of the presentation. We discussed this one, repudiation of an award made by an arbitrator and industrial court as well. Yes, repudiation must be published in a gazette. Repudiate kalot, take a gazette taker. The commissioner must ensure that the announcement, along with the statement regarding the period during which the impact of the provisions will be suspended, is published in the gazette. Right? Published in the gazette. Gazette taker, just you have to publish it. I mean, the Commissioner General has to publish it. Publishing the repudiation in a gazette, right? Further discussion. Notice of repudiation received by me. This is an example, a real example. Look at Vimala Veera, Commissioner General of Labour. At that time, I was acting just because until cabinet decision is granted. So, notice of this is, what I have gazetted during my tenure. Notice of repudiation received by me from Lanka Sadosa Limited, right? Now, please, number 108, York Street, Colombo 1, under section 21 of the Industrial Dispute Act, chapter 131. The award of the arbitrator dated 22 January 2017, binding on Mr. P.H.C. Pirish, number 52, 53, Nadagamua, Bemulla, and 494 employees and published in the Gazette of the Democratic Socialist Republic of Sri Lanka, dated so and so, is hereby published in the terms of section 20 of the same Act. In terms of section 22B of the Industrial Dispute Act, chapter 31, it is hereby declared that the aforesaid award shall cease, right, to have effect on the end of after 14/6/2018. What does it mean? The award has been granted when? Award has been granted when? You have to go back to, it is not there, right? State 12 months period means 2017, 15th of June 2007. 15th of June 2017, award has been granted. So it has effect until this period. It has to be gazetted, right? So extraordinary gazette, this is the gazette number. It is gazetted one. Okay, well, the period during which it remains in effect after repudiation of the award. Look at this. Section 18(2). The date that marks 1 year since the date of enforcement. Award එක දීපු දවසේ ඉඳලා බලන්න. ඒක end වෙන්නේ කවදාද? Date of enforcement. 5th of January 2020. Example. Right? I mean, the award has been granted on this date. The date by which the money must be deposited according to the provision. මොනාරි මුදලක් ගෙවන්න කිව්වා නම් ඔක ගෙවන්න ඕන කවදද? Within one month period, එක පහයි, ඒ කියන්නේ 30th of January 2020 ගෙවන්න ඕන. The date that marks 3 months from the date the award was received by the Labour Commission. The date that marks 3 months. මාස 3ක් යනකම්. Right, මාස 3ක් හරි බලන්න. 3 months from the date the award was received by the Labour Commission. Commission එන්න බෑ award. Arbitrator දෙන්න ඕනේ. Arbitrator must submit an award to the commission. Then the commission should gazette it. So, how does it end? The date the rejection was received by the Labour Commission. Right. The date, March, right? කවදාද? 20th. මාස 3ක් යනවා. පස්වෙනි මාසේ 30. Why? Right. Where does it say? No. The date that marks 3 months from the date the award was received by the Labour Commissioner. Let me put this. The date the rejection was received by the Labour Commissioner. Rejection එක received උනේ කවද්ද? 30. 3.1. එදා ඉඳලා මාස 3. From 3.1, 4.1, 5.1, 5.30. එක 6.1කට යන්නේ නැහැ නේ. තේරුණාද? 6.1 නෙමෙයි. ඉතින් ඉස්සෙල්ලා දවසේ එන්න ඕනේ. Right? So, this is the date the rejection was received by the Labour Commissioner. When was it? 1st of March 2020. From this date, the date that marks 3 months from the date the award was received by the Labour Commission. What? The date that marks 3 months from the date that award, sorry, made a mistake, right? The date that the repudiation, right? Repudiation, not award, right? Other. Repudiation was received by the Labour Commission. 30th of May, sorry, May 2020. Now, 12 months is when? ඒ කියන්නේ මාස 3ක් සාමාන්‍යයෙන් මේක දවසේ වෙච්ච දවසේ ඉඳලා මාස 3ක් බලනවා. බලලා තමයි ඇක්ෂන් ගන්න. හැබැයි මේ දිනේට before මෙතෙන් අවුරුද්ද යනවා මෙතෙන්. right? The date of enforcement 5th of January 2020. Then 12 months after 12 months means 4th of January 2021. Right? This is ගන්න ඕනේ 5යි සාමාන්‍යයෙන් 5යි විතර පස්සේ තමයි බලන්නේ. මොකද මේක රිජෙක්ට් කරලා මේගොල්ලොන්ට අවෝඩ් එකට මොකද රිට් එකට යනවද නැද්ද බලන්න ඉඩ දෙනවා. රිට් එකට යන්න ඉඩ දෙනවා පොඩ්ඩක්. Okay, because repudiated. And then commissioner may wait for another 3 months. And then after that it will be the commission, if not if award is not adhered by the party, then commissioner can go to magistrate court to impose it. This is very important. Entire, the summary of arbitration and industrial code. Dispute. The dispute is there. And here, not of, you have to make it correct. O, arbitrator, O, OR, O. Not of. OR, O. මම ඊළඟ ටික හැදුවා මගේ පෙන් එකේ උක තියෙනවා මෙහෙට දාපු එක මම මේ ගත්තා. ටෙක්ස්ට් විදියෝ ඊර නින්ද යන්නේ නැහැ ආපහු බලන්න ඕනේ කියලා. ඒක බලනකොට මේ සිංගල් මෝල් කොටේකුත් තිබ්බා. හරි. ඕක මේ එන ගමන් බැලුවා බලනකොට පොඩි මිස්ටේක්ස් ටයිපින් එරර්. ඒක හැදුවා මගේ පෙන් එකේ. දැන් මේක දාපු හින්දා මම ආයේ ඒක මාරු කරේ නෑ. මොකද මේක competitive මේක ආයෙ හදන්න ගියාම තව වරුවක් යනවනේ. Right. Anyway, so dispute refer for arbitrator or industrial code. OR. Right. Participants from online, right? Make some corrections. do it by yourself. So in the arbitrator or industrial court. Then remember, arbitrator or the industrial court give what? Gives orders, not orders. What? Award. Award. So then, say some money involved in the award. Money to be paid by the employer to the employee. Say X amount of money. Back wages or whatever, right? Compensation. So that amount of money, if the aggrieved party, mainly the employer, can directly go to court of appeal by way of writ application against the award. However, in order to go to court of appeal by way of writ application, if some money has involved or determined by the arbitrate award, so that amount of money should be deposited, as we call it, security deposit, with the Commissioner General of Labor. If the security deposit, say X amount of money, award pension, say 10 million rupees to be paid by the employer to X number of workers. So that 10 million, before go to court of appeal, that 10 million must be deposited with the Commissioner General of Labor. That money will be deposited in a separate account under the Commissioner General of Labor in BOC or People's Bank. So which attracts annual interest rate in interest. So without depositing that money, the employer cannot go to court of appeal. Why? Act was amended in 2022. The provisions of the Act. No one can violate the Act. Right? Provisions of the Act. So the employer neither accept, neither adhere to the award, no approach to the court of appeal. Employer is silent. So then, it is the duty of the Commissioner General or Commissioner or Labor Department to go to magistrate court for what? To implement the award. Before go to magistrate court, it is the duty of the labor authority to make sure that the aggrieved party has not approached the court of appeal. බලනවා තමයි දාන්නේ. ඉක්මන් වෙච්ච එක්කෙනා කමිෂනර් ජෙනරල් ඉක්මන් වුණොත් අර court of appeal යන්න කලින්. එතකොට මේ proceed. So magistrate court assumes that now why the commissioner has gone to the magistrate court to implement the award. Why? Employer has not adhered to the award and not approached to the court of appeal by way of writ application. So then imagine that the magistrate court gives an order in favor of workers. Right? It means that employer, the court decides, employer must adhere to the award. Okay? So at this point, here, the employer didn't go to court of appeal. did not act neither to adhere to award as well. But then the commissioner went to magistrate court. Magistrate court decided the employer has to adhere to the award. Then at this point, the employer can go to high court. High court against the decision of the magistrate. Against the decision of the magistrate. Right? Using in favor of worker. Right? So, but before go to high court, that money, the 10 million say, right, to be deposited as security with the Commissioner General of Labour. And then after that, say, assume High Court also affirm the decision of the magistrate. Again, the employer can, already money has been deposited now. Again, the employer can go to Court of Appeal against the decision of the High Court. The Court of Appeal affirm the decision of the High Court. Then again, employer can go to Supreme Court. Okay. For example, Supreme Court also affirm the decision. The what you call magistrate court and high court and Court of Appeal, everything is affirmed by the Court of Appeal. It means that the employer has to pay. In order to implement this Supreme Court decision, Commission again has to go to magistrate court. Because Supreme Court has what? Supreme Court has affirmed the decision. Right? Supreme Court this one and this one affirmed. Based on the Supreme Court decision. Supreme Court decision Commissioner magistrate court. මෙහෙමයි මේ පනතේ තියෙන අවුරුද්දයි මැක්සිමම් මේ පනතට අවුරුද්දයි
ඒක තමයි කෝට් එකකදී ගියාම අපි කෝට් ඔෆ් අපීල් එකේ තියෙනදී ජජ්මන්ට් එක වෙනස් අනිත් පැත්තට.
Yeah, okay.
එතකොට security deposit කරනවා.
So still against the decision අනිත් පැත්තට යනවා කියලා කියන්නේ in favor of employer, in favor of employer, right? So then other party can go to Court of Appeal, right, against the decision of the High Court. Yeah, නැතුව ඉන්නවා කියමු.
Deposit එක සදතිපේ right?
මේකට against යනවා High Court.
High Court එකෙන් High Court එකෙන්
affirm කරනවා.
Court of Appeal එකට ගිය වෙලාවට
reject කරනවා.
ඔව් මේක employer පැත්තට favor ඔබට security deposit එක මොකද වෙන්නේ? මොකද එයා තව option එකක් තියෙනවා Supreme Court යන්න පුළුවන්.
යන්නේ නැහැ. employee යන්නේ නැහැ. එතකොට මේ security deposit එක මොකද කරන්න ඕනේ? එයාගේ money interest එකත් එක්ක කාටද ගෙවන්න ඕනේ? employer ට ගෙවන්න.
හැබැයි Supreme Court යනවා නම් එයා ඒ Supreme
employee
Supreme Court යනවා නම් employee එතකොට අර security deposit එක
එහෙමම තියෙන්න ඕනේ. Final decision until final decision come. So imagine, if this process, how long does it take?
I feel process එකම වැඩි.
ඌව වෙනස් කරන්න ගියාම අධිකරණ ප්‍රශ්නක් තියෙනවා. අපිට වෙනස් කරන්න පුළුවන් නේ පොඩි කොටසයි. Well, anyone, right, from the participants online, do you have any question? Any question? Oh. So if not, let me move to next slide.
ඒකයි වෙනසක් නැහැ කරනවා
ඒගොල්ලෝ පත් කරන්නේ ප්‍රෙසිඩන්ට්. අර ඒකයි නේ පොඩි අර. නැතුව එකම දේ, but you know, under the industrial code, you know, appeal to minister is there, right, before go to court of appeal. Now, the final one, labor tribunal. This one also I discussed at the beginning. But මේක කඩලානේ තියෙන්නේ. ඔක මට කිව්වනම් මේක කඩලා යන්නේ කියලා. මුල් දවසේ අපි in general කතා කරා. මම දැන හිටියේ නෑ. මේක තව ඔයාලට තියෙනව නේද මොකක් හරි. So ILO conventions ඒක ඉවරයි නේ. ඒක මම නේද කරන්නේ. Labor tribunal. Last resort. I mean, under the industrial dispute, settlement of industrial dispute, this is one of the mechanisms. What do you mean by labor tribunal? A workman or a trade union? Just one second. What are these in there? I the live reader. Are you mang endone? Yes, my daughter has come. Trick. Definitely but so in our okay, a workman, a trade union, on behalf of a member, may make an application in writing to a labor tribunal for relief or redress in respect of any of the following matters. පහත දැක්වෙන කාරණා සම්බන්ධයෙන් සේවකයෙකුට සේවකයා වෙනුවෙන් වෘත්තීය සමිතියකට මොකටද කම්කරු විනිශ්චය සභාවට ආයුධම් පතක් ඉදිරිපත් කළ හැකියි. ඒ කුමන කාරණා සම්බන්ධයෙන්ද? A. A termination of his service by his employer within 6 months of such termination. That is the time mark, right? If your employment is terminated by your employer, you must go to labor tribunal within 6 months from the date of such termination. After 6 months, you cannot go to LT. Some people, knowing or unknowingly, they don't go to labor tribunal, neither come to labor department. After 6 months, they can't go to labor tribunal, and they approach the labor department under what? Under section 31B of the Industrial Dispute Act. Sorry, under the Industrial Dispute, not 31. 31B is this approach to the labor tribunal, 31B. So they fail to go to labor tribunal within 6 months, and then come and lodge a complaint with the labor department. Sometimes, due to the influence of the minister or some other party, labor authority also entertain such application. But labor department, if it is you know, direct termination, right? Under section 2, right? Illegal termination. Labor Department can, make an order. Otherwise, it's not illegal. Say, something else. So then the Labor Department will take up that matter as a dispute. And before go arbitrate. But during my tenure, I discourage because once you lost or your employment is terminated, it is your duty to go to labor tribunal or come to the Labor Department and lodge a complaint. Right? If you approach to the Labor Department, you are definitely advised. If you wish, you should go to, you can go to Labor Tribunal, but within 6 months. That advice, even the application, there is an application to be filled up by the, lodge a complaint. It says termination. If it is termination, within 6 months, you are supposed to go to Labor Tribunal. If you wish. So, if employer fails, right, employee fails to go to, if it is, very, very, how can I say, on sympathetic ground, sometimes the worker has met with an accident, right, bed rest 4-5 months, so he cannot go to it. In such situation, by looking at the situation, yes, right, we can entertain the application. Otherwise, they should go to Labor within 6 months, either to come to the Labor Department or to go to
But when it comes to the department, there is no
like this. Either you within 6 months, you have to come to the Labor Department or the Labor Tribunal. You have to approach. But if time bar has gone, we cannot, it is, the termination, Labor Department entertains such an application as an industrial dispute, right? Not as termination. But in order to act under the provisions of Termination Act, you have to come to within 6 months.
what you're saying is still they can consider termination case.
Termination cases, but not as termination, but considering it as industrial dispute. එතකොට යන්න ඕන industrial dispute act එක. Termination act එකෙන් යන්න බෑ. Right? Termination act එකේ යනවා නම් කමිෂනර්ට දෙන්න තියෙන්නේ එක order එකයි. If it is illegal termination, reinstate. ඒක කරන්න පුළුවන් නේ අර මාස 6 ඇතුළත. එනවා termination. අර මේ මාස 6 ගිහිල්ලා LTR නැතුව මෙහෙට එනකොට ඒ application entertain කළ යුතු නැහැ. නමුත් sympathetic ground කලකලා ඒක entertain කරනවා. එතකොට then the labor authority has no jurisdiction to take decision under the Termination Act. But considering it as an industrial dispute, because termination also industrial dispute, comes under industrial dispute. Under the Industrial Dispute Act, conciliation and arbitration. Right. Suppose. හැබැයි ඒක කළ යුතු නෑ. ඒක unnecessary burden එකක්. ඔව්. LP යනවා කම්පැනි ඩිසිෂන් එකෙන් satisfied නෑ.
Provincial High Court එව යන්නේ නැහැ. නැතෝ Labor Department under industrial dispute.
No. if you go to LT, there is no reverse. Right? You can't, whatever the case, being heard at LT.
It's already judgment given.
Judgment given, then the next procedure is go to Provincial High Court. You can't come back to the Labour Department. No provision. Even though, say, without going for LT, they come here. So, award is granted. Worker is not satisfied by the award. So then they can't go to LT. The affected party has to go to where? Court of Appeal. Remember the procedure. You can't reverse back. Reverse. අපව වෙන්න බෑ. ගිය තැනින් ඉස්සරහට යන්න. පාත් එක. ඒ පාත් එක යන්න. ආපහු there is no backward. Okay. ඒ කියන්නේ අර අපි කිව්වේ LT ගේ අහන කේස් එක ආල ඉවරුණයි කියන නෑ. අනවා හරි ආල ඉවරුණා හරි ආයේ මෙහෙ ගන්න බෑ. මෙහෙ ගත්තු කේස් එකක් ආයේ LT එකේ අහන්න බෑ. මෙහෙ ගත්තු decision එකට against කියන්නේ award එකට against ඊළඟට යන්න තියෙන court of appeal. ඒකට යන්න. එහෙම නැතුව ආයේ LT යන්න බෑ. හරි? Okay, well. So B, the question whether any gratuity or other benefits are due to him from his employer on termination of his services and the amount of such gratuity and the nature and extent of such benefit. What does it mean? If when you the workplace where you are working, there is no total number of employment is less than 50. Less than 50. Okay. So during the last, previous 6 months, during the previous 6 months, then you're not entitled for gratuity. Under the Gratuity Act. Gratuity Act applies to the workplaces where 15 or more workers have been employed. Okay? How the gratuity is? Right. 15 or more workers. But say the place you are working, you have worked 10 years, but no 15 employees, only say 12, 13. Still you feel that I need gratuity. So, section B, B. The question whether any gratuity or other benefits are due. What a gratuity. So you have, this is under the, the provisions, Labor Tribunal, Industrial Dispute Act. You can go to LT asking gratuity. Okay? Whether it will be granted or not, something else. What is that? What is that thing?
So, activity and all the benefits can be.
Activity hari compensation කියන්න පුළුවන්. Right? ඔයා හිතනවා නම් මට යම්කිසි දෙයක් ලැබිය යුතුයි කියලා, but you are not covered by law. Right? Law in the sense that if it is gratuity, you are not covered by the Gratuity Act. Right? Why? The only reason is there may be two reasons. One is you have not worked 5 years. The second may be there is no 15 no more employees.
What is the rationale for this 15 now being the gratuity? Why
You could have asked this question when the Gratuity Act was, the discussed. The rationale is threshold 15, At that time, small, small micro enterprises, sometimes small, small enterprises, small enterprises. Even, there are different categories. Micro is less than 10, right? Medium is, more than 10, and sorry, small is less than 15, but more than 10, something like that, right? So the micro enterprises, small, with small numbers of employers, they are just surviving. Those companies are just surviving. They are not, that was, idea at that time, not making much profit, right? So just they provide an employment opportunities for workers, but just, bank loans and all these, just survive. Such a company, if we compel them to employer to pay gratuity, tomorrow it will be collapsed.
But I think there can be certain established small.
Yeah, I'm accepting it, but my reading in this regard is, at that time, whatever the reason, it has been decided 50. As I know, because this threshold at that time, the has been decided by looking at the economic situation at that time in the economy, right? Not now. You have to go back to the centuries. I mean, the decades before. I mean, ago, 1950, right? 1950, small, the companies. You can't argue that even though it is a small number, well off at 1950 not at that time. So that may be the reason.
Ideally, the amendments could have been addressed.
Sorry.
Amendments, subsequent amendments.
In the new drafted one, even you employ one worker, but you have to complete 5 years, right? Then you are entitled for credit. Even one small guy serving in a boutique, silver credit, given no now you pass.
And ඔක්කොම අර එකට දාලා දෙන්න.
ඔව්.
මොකද යන්නේ
ඒකට කියන්නේ employment tax. New employment. New කියන වචනේ දැන් අපි කියන එක employment tax.
ඔක්කොම මේක තියෙනවා.
13ක් නැත්te EPF විතරයි. 13ක්.
ඒක පිළිගන්න.
නෑ ඒක separate social security මේක ඇතුළට ඒක වෙනම කතා කරනවා.
CDF එක.
EPF එක is not coming under the labor department. ඒගොල්ලෝ follow කරන්නේ අපි මේක කරපු ගමන් ඒගොල්ලෝ ඒක කරනවා.
අතේ 13 ETF උත් නැහැ.
EPF නෑ. කමිෂනරට තියෙන 14යි. කමිෂනරට තියෙන 14යි. 16ක් තියෙනවා. ETF එකයි වන්දි එකයි අයින් කරාම කමිෂනරට බලය තියෙන්නේ 14කට විතරයි. එකෙන් EPF එක අයින් කරාම 13යි. ඒ 13ම repealed, rescinded. All provisions have been included. It does not talk about the gratuity. I mean, it's just the chapters. Settlement of industrial dispute. It doesn't talk about separately, but it includes everything, right? Social security, terms and conditions of employment, termination of employment, likewise, chapter by chapter, and occupational safety and health. There is no wages board. In the future, if that one is, enacted, no wages board. All workers are to be equally treated. The provisions applicable now, SOPAN office, the SOPAN office, all provisions in the SOPAN office will be applicable to all workers. No wages put.
So likewise, as you said, the factory ordinance or like security, safety, on which they applicable to the top end of it.
Yes,
So that's the-
yes. Yes. This is a remarkable thing what we did, but
So where is it?
I don't know. At that time, I submitted it to legal draftman. We had a couple of, discussions with our team. They went there and discussed, and it was at the final stage. But I don't know now.
But it has to be shared with the.
No, it is up to the new government. We share it. But trade union always, make their objections.
So, recommendation,
මේමයි හැමතිස්සෙම යූනියන් කියන දේම අහන්න බෑ. ඒගොල්ලෝ හැම එකටම විරුද්ධයි. දැන් නිව් ගවර්න්මන්ට් එකේ අය ඒකට විරුද්ධ වුණා. ඒ වුණාට දැන් මම හිතන්නේ ඉස්සරහදී කරයි. නොකර බෑ. නොකර බෑ. මේ රටේ යන්න බෑ. ඒකද මම දැක්ක මේ අයි නාගමු බැනබැන හිටින් අනිගේ ලේබල් එකම ආපහු ගින් හදලා මේගොල්ලෝ. හදලා මෙහෙමයි එහෙම නැතුව රට යන්න බෑ දුවන්න බෑ. We have to protect both rights of the working people as well as the continuity of the business.
make a main decision higher and fire policy
I am private policy මෙහෙමනේ. Say for example now you are an employer. If I am not giving, if I am not competent enough, inefficient, right? Inefficient, low productivity, even though I have been trained low productivity. So you have the right to fire, but you have to pay compensation according to the compensation formula. You don't need to go to Commissioner General to get the approval. That is what, you pay for compensation and say, but in case the worker complained to the labor department, there is a procedure. You will be questioned, right? And if you have really taken a bad decision, the worker is, performing due to personal reason, you terminate, and the worker approach to the labor department, then if labor department realizes that you are, because an appeal procedure is there, right? You have done it purposely, not in good faith, then you will be ordered to reinstate. Right? You have to have rationally. Say for example, if you compliance branch is there, you have to close the compliance branch because you don't have orders to send to other countries. Export. So then keeping the compliance branch is useless. You're using money. So then, you have to rationalize, write to the Commissioner General. In case, right, you have to record this everything and pay them and ask them to leave. Right? But if they do not, you can terminate them. They will come here and complain. Then you have to have proof. Evidence to prove that. These are the provisions in that. So I had to close my business. So then the provision is there. Business has to be closed down due to any reason beyond the employer, right? The beyond the control of the employer. So those provisions are there. You can hire and fire here.
Employer from side of employer, they should check whether redeployment elsewhere is possible.
Yes. You come back. You have to train වෙන තැනක දෙන්න පුළුවන්ද බලන්න ඕනේ. So redeployment, retraining, right? Redeployment. Well, if not possible, then employer can terminate. You don't need to go behind the commissioner because the Commissioner General takes time to decide. Until, even though they are not working, you have to pay. That part can be avoided. Okay. Right. Well, see, such other matters relating to the terms of employment or conditions of labor of a workman as may be prescribed. ඕන එකට මේවා LT එකට යන්න පුළුවන්. Labor Tribunal jurisdiction. Application to a labor tribunal, section 31B. This is a B, right? A workman or a trade union on behalf of a workman who is a member of that union may make an application in writing to a labor tribunal for relief or redress in respect of any of the following. So mainly I have already, because the termination of his service by his employer can go. The question whether any gratuity or other benefits are due to him from his employer on termination of his services and the amount of such gratuity and the nature and extent of such benefit, where such workman has been employed in any industry employing less than 15 workmen or any date during the period of 12 months, preceding the termination of the service of the workman who makes the application or in respect of whom the application is made to the tribunal.
මාසෙක හරි 16ක් හිටියොත්
මාස 12 ඇතුළත එක මාසෙක හරි 16ක් හිටියොත් gratuity act එකෙන් යන්න ඕනේ. Right. So, application to a labor tribunal against section 131B. See, right? The question whether the forfeit of gratuity in terms of the Payment of Gratuity Act number 12 of 1983 has been correctly made in terms of that act, and again the gratuity take a forfeit karagana, wrongly calculated. So against that one also the worker has, after termination, the worker has, as a result of termination, termination වෙනවමනේ gratuity ගන්නවා කියන්නේ termination. එක gratuity එක හරියට calculate කරලා නැද්ද කියලා නෙමෙයි. මතක තියාගන්න. If your gratuity has not been calculated properly, you should approach to the labor department. But the forfeit of gratuity has not been, calculated properly. So for that case, you should go to LT, right? Labor tribunal. Such other matters relating to the terms of employment, so we discussed it. On these matters, you can go to labor tribunal under section 31B of the Industrial Dispute Act.
The point is, when 15 matter, say less than 15. That is say 15 or
Less than 15, right? 15 or more, you are covered by the legislation, right? I mean, you can come to the labor department as well. If it is less than 15, not 15, 15 or more, you are covered by the law. Termination Act and the Gratuity Act as well. Less than 15, not 15, less than 15. Again, you are not covered by the Termination Act, you are not covered by the Gratuity Act. So then only the place that where you can go is the LT, Labor Tribunal. So section 31B4, the Labor Tribunal is not bound by the terms and conditions of the contract of employment. Remember, whatever mentioned in the contract of employment, the Labor Tribunal is not bound by the terms and conditions of the contract of employment. Okay, right. Section 31B7, the complaint should be made to the tribunal within a period of 6 months from the date of termination of the services of the workman. Within, otherwise time bar. එහෙම ගියාම අඬාගෙන යනවා labor department එකට. අනේ මට මේක කොහොම හරි කරලා දෙන්න. අපි නම් කරන්නේ ඉතින් මිනිස්ලා හරි කවුරු හරි කිව්වම ඕක බෑ කියන්න බෑනේ. ඉතින් එක්ක ගිහිල්ලා මිනිස්ටර්ට ආඳුරන කෙනෙක් මාර්ගෙන් තියනවා. ඒකට ඉතින් ඕක එන්ටර්ටේන් කරලා ඕකේ එක ගන්නේ ඒකට ටර්මිනේෂන් හැටියට ටර්මිනේෂන් තමයි. බල අnder LTA sorry Industrial Dispute Act එක යටතේ තමයි ගන්න. dispute taken. Right. Next. Right. Relief granted by the LT. Relief. මොනවද LT එකට grant කරන්න පුළුවන් relief? Relief granted by the LT. Reinstatement in service with or without back wages or with part of back wages. Right? Compensation in lieu of reinstatement. Reinstatement එක වෙනුවට compensation. Awarding gratuity on a specific application where the employer has less than 15 employees. එතකොට LT එකට පුළුවන් ඕනනම් gratuity ගෙවන්න කියලා නෙමෙයි. Order pertaining to correctness of the gratuity, forfeiture gratuity. Examples, court decisions in that regard. MA Lanka Private Limited versus CGL, Court of Appeal writ, decided on 2010. Selinco General Insurance Limited, CGL, decided on 12th of December 2023. 2023. Right? ඒ කියන්නේ මේම පුළුවන් කියලා මේම දීලා තියෙනවා. ඒ දීපුවට court decisions තමයි මේ තියෙන්නේ. ඇයි කියන්නේ LT එකට against යනවා කොහෙටද මේ relief granted by the LT. මොනවාද LT එක grant කරාම ඒගොල්ලෝ මේක court of appeal යන්නේ. court of appeal relief granted by the LT. Reinstatement in service, the order, these are, some of the court cases.
So we are asking a case of the forfeiture of gratuity.
එකයි
Okay, කියන්නේ
මෙහෙමයි. forfeiture of gratuity දෙන්න පුළුවන් කියන දීපුවා. right? ඒවට against employer යනවනේ. Employee. නෑ employee නෙමෙයිනේ යන්නේ. එයා employee in favor of employee දුන්නොත් මොකද වෙන්නේ?
employer
appeal කරනවානේ. එහෙම කරලා යනවා. හරි. එතකොට employer appeal කරලා යනවා court of appeal එකට. court of appeal කියලා කියන්නේ පොඩේ. මෙතන කියන්නේ මේ දෙක තියෙන්නේ මේමයි. reinstatement මේ LT grant කරන්න පුළුවන් මේවයි. හරිද? ඊට පස්සේ MA ලංකා private limited CGL කියලා කියන්නේ මේ CGL දීලා තියෙනවා decision එකක්. right? ඒ කියන්නේ මේක යන්නේ මෙහෙමයි. මේ නඩුවේ එන්නේ සේවකයෝ 15ක් නැහැ කියලා CGL සේවකයෝ 15ක් ඉන්නවයි කියලා පළ කළා gratuity දෙන්න කියලා order එක දෙන්න. මේක LT ගේ එකක් නෙමෙයි. එතකොට LT එකට grant කරන්න පුළුවන් මේවා. ඊට අමතරව මේ කාරණේ. right? In addition to that මෙතන වෙලා තියෙන්නේ සේවකයෝ 15ක් නැහැ කියලා තමයි. කවුද? සේවා යෝජකයා. Employer has to go to court of appeal. right? එතකොට සේවා යෝජකයා එහෙම ගියාට මේ decision එක දුන්නේ in favor of worker. ඇයි? 15 calculate කරන විදිහක්. right? 15 calculate කරන විදිහ තමයි අර trainees ලා ඉන්නවනේ. trainees ලාත් එක්ක calculate කරා. හරිද? employer ඒවත් නැතුව calculate එක එහෙම යන්නේ නැති එකට. ඒක මට හරියට කියන්න බෑ. You better right go to the type this case, you can get it. And Selinco Insurance versus CGL decided on මේකත් ඒ වගේ. කියන්නේ gratuity නැහැ කියලා තමයි මේගොල්ලෝ කියේ. හැබැයි කමිෂනර් gratuity කමිෂනර්ට against යන්නේ කමිෂනර් gratuity එක දීලා තියෙන්න බෑ. කමිෂනර් gratuity හරි. එහෙම නැත්නම් reinstatement හරි. මොනවා හරි දීපු එකට against ගියව තමයි මේ. right? කයි ඊට අමතරව මෙතන කියන්නේ මේ කාරණාවලට යන්න පුළුවන් කියලා. මේක මෙස් කරගන්න එපා මේක වෙන තැනකට එන්න ඕන එකක් මෙතෙන්ට වැටිලා. Any relief or redress may be granted by a labor tribunal to a workman upon an application made under subsection 1, notwithstanding anything to the contrary in any contract of service between him and his employer. In other words, LT can ignore contract and give some relief to the employee. එනිසා පත්වීම් ලිපියේ තියෙන දේවල් එතරම්ම බලවත් නැහැ. The LT shall make all such inquiries into that application and hear all such evidence as the tribunal may consider necessary, and thereafter make such order as may appear to the tribunal to be just and equitable. මොනවාද arbitration වගේම තමයි. මේ same wordings තියෙන්නේ ආ. ඕගොල්ලෝ පනතට ගිහිල්ලා බැලුවොත් පනතේ මේ wording ටික එහෙමම තියෙනවා. The procedure can be decided by the LT, unlike other courts that have to follow a very strict procedure. මේකේ LT එකේ එහෙම අර මහේස්ත්‍රාත් අධිකරණය වගේ එහෙම strict procedure එකක් follow කරන්න ඕන නැහැ. ඒකේ LT එකට තීරණය කරන්න පුළුවන්. දැන් LT එකේ පෙනී හිටින්න පුළුවන්. මැජිස්ට්‍රේට් එකට යන්න පුළුවන්ද ලෝයර් කෙනෙක් නැතුව? පුළුවන්ද බැයි? තමන්ටම පුළුවන්. හරිද කරුණෝ කියන්නේ. එහෙම නැත්නම් කවුද අරන් යන්න ඕනේ? ලෝයර් කෙනෙක් අරන් යන්න. රිප්‍රසන්ටේටිව් කෙනෙක් අරන් යන්න පුළුවන්ද? රිප්‍රසන්ටේටිව් කෙනෙක් අරන් යන්න පුළුවන්. MC එකට බෑ. රිප්‍රසන්ටේටිව් කියන්නේ is not a lawyer. right? එයා වෙනුවෙන් කරුණු කියන්න වෙන කෙනෙක්යි. but LT එකට පුළුවන්. lawyer වෙන්නත් පුළුවන්, trade union representative වෙන්නත් පුළුවන්. හරි? The next, these are the guidelines again, just an equity principle. I told you. These are some of the cases, right, with regard to just and equity principle. Millers Limited versus Ceylon Mercantile Industries and General Workers Union 1993, right? In this case, Vandaranayaka Justice observed that an award is just and equitable only if it takes into consideration the interest of all the parties. මේ කියන්නේ මේ just and equity principle එකේදී අනුගමනය කරන්න ඕන දේවල් ඉහළ උසාවි මගින් කියපුවා. I don't need to read everything. These are also, you can read it by yourself, right? Again, just an equity principle, right? Relief that can be awarded by the LT. Again, if the termination is held to be justified, the labor tribunal will dismiss the application. Right? Dismiss the application. If the termination is found to be unjustified, the labor tribunal can reinstate the employee with or without back wages, make an award for compensation for loss of employment. In the case of a domestic servant, personal secretary, personal clerk, personal attendant, or chauffeur, if the termination is found to be unjustified, the employer must be given an alternative to reinstatement in terms of compensation. බලන්න ලංකාවේ තියෙන එකම එක ඇක්ට් එකයි. මොනවාද? domestic servant ලා, personal secretaries ලා, couples ලා ආවරණය වෙනවා වෙන්න එකම එක ඇක්ට් එකයි තියෙන්නේ. අනිත් කිසිදු ඇක්ට් එකකින්, පනතකින්, ඕඩිනන්ස් එකකින් මේගොල්ලෝ ආවරණය වෙන්නේ නැහැ. මොකද්ද? කොහෙද ඉන්නේ කියන්නකො මට? LT තියෙන්නේ මොන ඇක්ට් එකේද? Industrial Dispute Act එක. We are just talking about LT. LT comes under the Industrial Dispute Act. වෙන කොහෙවත් LT නැහැ. LT එන්නේ Industrial Dispute එකේ විතරමයි. right? ID Act එකේ provision වලින්ම තමයි Industrial LT හැදිලා තියෙන්නේ. නැතුව EPF Act එක LT එකට අදාළ නැහැ. Gratuity not related to LT, right? Payment of wages, all other, things not related to LT. Only industrial dispute. එතකොට මේක විතරමයි. මේ industrial dispute tax එකේ විතරමයි මේ කියන domestic servant ලා, personal secretary, personal clerk, personal attendants or chauffeur කියන්නේ පෞද්ගලික රියදුරු, right? If the termination is found to be unjustified, the employer must be given an alternative to reinstatement in terms of compensation. Right. Both employer and employee can appeal against the decision of the labor tribunal to the provincial high court on a question of law. Provincial high court only. Right? එහෙමයි. යාළුවෝ ඩිවි ඩිපාර්ට්මන්ට් ආවට බෑ. ජුරිස්ඩික්ෂන් එක නෑ. එල් කියන්න පුළුවන්. ඒ කන්සිලියේෂන් බෑ. ආර්බිට්‍රේෂන් බෑ. එල්ටි පුළුවන්. මම හිතනවා ඔයාලා යමක් ඉගෙන ගත්තයි. ඔව් අද ටිකක් ඉක්මනට ඉවර වෙයි බං. මොකද මම ටික ඉක්මන් ගියා අර මැදට. ඒවා කලින් කියපුවා නිසා. An appeal against LT order. The employer can appeal to the provincial high court against the order of tribunal 30 days from the date of the order. Within 30 days from the date of the order. It is mandatory depositing the required amount of money under section 31D4. මේ 31D4 එකක් තිබුණේ නැහැ. තුනයි තිබුණේ. ඔය එක අලුතෙන් ඇඩ් කරේ 2022. right? If the employer appeals, right? Vimala Pereira versus right Lakmali Enterprises, we have Supreme Court decision as well. Been an again මේ කියන්නේ depositing money කියන එකට නෙමෙයි මේ තියෙන්නේ. මේ court decision එක මෙතන දාලා තිබුණට Vimala Pereira versus ඒ කියන්නේ provincial high court ගිහිල්ලා ඒ කියන්නේ මෙතන තියෙන්නේ මේ Vimala Pereira versus Lakmali Enterprises 2003 1 SLR Supreme Court. ඒ කියන්නේ Supreme Court එකත් මෙහෙම කතාවක් කලින් කියලා තියෙනවා. අනතේ තිබුණේ නැහැ. ඒත් මේක ඉන්කෝපරේට් වෙන්නේ පනතට. ඉන්කෝපරේට් වුනේ නැත්නම් මුත් කරන්න බෑනේ. So the idea of the opinion of the Supreme Court in order to implement must be incorporated into the law. ඒක incorporate කරන්න ඕනේ හින්දා තමයි 2022 amendment එක ගෙනාවේ. right? මොකද මේකෙදි කතා වෙනවා මේක මෙච්චර කාලයක් ගියාම මේ මුදලගේ value එක මොකක්ද? මේ Supreme Court decision එකේ මේකේ කතා වෙන එක තමයි මේ value එක මොකක්ද? right? ඒ නිසා මේ හරිනම් මොකද වෙන්න ඕනේ මේක මේ එනකොට මේ මුදල් තැම්පත් කරලා ඉන්න ඕනේ කතාව. ඒකට ඒක එහෙම කිව්වට වැඩක් නැහැ නේ. 2003 එහෙම කතාවක් කියලා තියෙනවා. මේ කියන විදිහ. එහෙම කිව්වට වැඩක් නැහැ. ඒක ඉම්ප්ලිමන්ට් කරන්න නම් ඒක මොකද ගේන්න ඕනේ? law එකට ගේන්න. That is what we did in 2022. Being an employer fails to comply with any order made in respect of him by a labor tribunal shall be guilty of an offence under this act. Any modification or alteration made to the order is null and void. මේක ඕල්ටර් කරන්න කියලා යන්න බෑ. හැබැයි against the LT decision order can go to provincial high court. ඒක වෙනස් කරන්න ඕල්ටර් කරන්න එහෙම බෑ. Next. Offences related to settlement, award and orders. Right. Failure to comply with orders, awards or orders. Keeping in employment any workman on less favorable terms than those specified in such settlement, award or order. Offences related to settlement, award and offences. What it says? Offense එකක් failure to comply with the award or order. ඒක offense එකක්. වරදක්. award එක පිළිපැද නොපැදීම, order එක පිළි නොපැදීම, award එකට adhere නොවීම වරදක්. offense එකක්. Keeping in employment in any workman who less favorable terms than those specified in such settlement, award or order. Settlement එකකදී order එකකදී යම්කිසි සේවකයන්ට යම්කිසි ඒ අදාළ සේවකයන්ට order එකක් award එකක් දෙනවා. මෙහෙම සලකන්න කියලා. should be treated as this. සමහරට settlement එකක් වෙන්නත් පුළුවන්. ඒත් ඒක අදාළ වෙන්නේ ඒ හා සමාන ඒ ආයතනයේ ඉන්න ඒ සේවක කොටසට විතරක් නෙමෙයි. right? අපි හිතමුකෝ මැෂින් ඔපරේටර්ස්ලා 10 දෙනෙක්ට ප්‍රශ්නයක් එනවා සෙටල්මන්ට් එකට යන්න. ඒකට සෙටල්මන්ට් එකේදී යම්කිසි එකඟතාවයකට එනවා මොන හරි පඩිය මොකක් හරි එකකට. හැබැයි all machine operators are entitled to that. ඒකයි කියන්නේ මේ keeping in employment any workman on less favorable terms than those specified in such settlement. Settlement එකේ specify කරපු ඒවා award එකේ specify කරපු ඒවා order එකේ specify කරපු ඒවා වඩා less favorable දෙන්න බෑ. තේරුණාද? ඒ විතරක් නෙමෙයි. අපි 10 දෙනෙක් ඉන්නවා. 10 දෙනා machine operatorsලා. පාටි එක වෙන්නේ අපි 5 දෙනෙක් විතරයි යන්නේ. අනිත් අය යන්නේ නැහැ. ඒකට මේ දෙන ඕඩර් එක අනිත් ඒහා සමාන අනිත් ඔක්කොටම පොදු වෙනවා. එහෙම නැත්නම් ඩිස්ක්‍රිමිනේටර්. ආයි ඩිස්පියුට් එකක් වෙනවා. හරි? less favorable බෑ කියන එකකින් අදහස් කරන්නේ අදාළ සේවකයන්ට අඩු කොන්දේසියට සලකන්න බෑ කියන. Commencing a lockout or strike with a view to proceed procuring the alteration of the terms of a settlement award or order. Again, commencing lockout කරන්න හරි strike කරන්න හරි බෑ දීපු settlement එකේ තියෙනවා alter කරන්න වෙනස් කරන්න කියලා order එකේ තියෙනවා එහෙම බෑ. ඒක open set. Terminating the service of or reducing to a lower grade or class or otherwise, right, punishing a workman without good cause for the reason that he has become entitled to the benefits of any settlement award. කියන්නේ එයාට අර malpractice කියන්නේ නරක treatment කරන්න බෑ. Commencing, continuing or participating in or doing any act in furtherance of or inciting a lockout or strike in any industry after an industrial dispute in that industry has been referred for settlement to an award in respect of such dispute has been made. Again, ආරවුල arbitrated or LTA, sorry, labor industrial code දැම්මට පස්සේ lockout strike බෑ ඒව නවත්තන්න. ඒවා offense එහෙම කරොත් ඒක වරදක්. Enforcement of award and offences. I already explained. If the employer fails to comply with the order, the commissioner may file a case against the employer under the section 136 of the Criminal Procedure Code Act number 15 of 1979. Right? කොහෙවත් Industrial Dispute Act එකේදී criminal procedure ඒව ඉන්නේ නැහැ. හැබැයි award එකට adhere වුණේ නැත්තම් magistrate court යනකොට follow කරන්න ඒ කියන්නේ මේ criminal කියන්නේ offense එකක්. වරදක්. ඒකයි criminal procedure එක follow කරන්නේ. The case will be tried summarily. ඒ කියන්නේ summary trial කියලා අපි කියනවා. ඒ කියන්නේ ලඝු නඩු විභාගයක් කියලා සිංහලෙන් කියන්නේ. හරි. ඒ කියන්නේ ලොකු කාලයක් ගන්න නැහැ. The burden of proof lies on the employer. ආම්පුතාමද තමයි පැවරෙන්නේ burden of proof. The employer shall be liable on conviction after summary trial before a magistrate a fine not exceeding 5,000 rupees or to imprisonment of either description for a term not exceeding 12 months or both such fine and imprisonment. So the Industrial Dispute Act එකේ යටතේ දඩේ වෙන්නේ මෙන්න මේ.
මේ amendment එකේද මේ fine එක වැඩි කරන්නේ
නෑ right නේ වැඩි කරේ. fine එක වැඩි කරේ. Industrial dispute, I'm reminding, right, employer to furnish a security in respect of any application to the High Court dissatisfied with an order of a magistrate court. Magistrate court එකට එලින්ම කොහෙටද යන්න පුළුවන් කොට කැපිලා යන්න පුළුවන්. යන්න නැතුව ඉන්නවා. ඒකට labor department goes to magistrate court. Right? Magistrate court එකේ decision එක in against the worker, employer, in favor of worker, then at that time, depositing the money, the employer can go to High Court. අර මං අර කිව්වේ පෙන්නුවේ යන්න පුළුවන් විදි. Failure to comply with an award of an arbitrator, industrial court and orders of the labor tribunal. මේකත් ඒ කියන්නේ යන්න පුළුවන් විදිය මං කලින් කිව්වා. කමිෂන යනකොට කමිෂන මැජිස්ට්‍රේට් එකට යනවා. නෑ ඒක මෙතෙන්ද බලපාන්නේ නෑ. ඒක ඒ වෙනස් වීම මේකට බලපාන්නේ නෑ. කියන්නේ මේක ෆයින් එකක් නේ. දඩයක් නම් මේ දඩ වෙනස් වීම ඒකේ වෙනස් වුණාට මේකේ එක තමයි එතෙන්ද බලපාන්නේ. මෙතන කියන දඩේ ඒ ක්‍රිමිනල් කෝඩ් එක කියන එක අපි උපයෝගී කරගන්නවා මැජිස්ට්‍රේට් කෝට් එකේදී මේක දඩේ ගන්න. ෆයින් එක. නැත්නම් ඉම්ප්‍රිසන්මන්ට් යන්න බෑනේ නැත්තම්. ඒකේ සමහර වෙලාවට එක එක කාරණා වලට තියෙන්න පුළුවන්. ඒතකොට ඒකේ රෙෆරන්ස් උනාට මේකේ විදිහට තමයි යන්නේ. So problems with current LT system. The entire case may take about 3 to 4 years depending on witnesses, complexity, right? Administrative difficulties exist, right? Right. The order made by the LT is then difficult to carry out, especially if the employee is given the job again. Job එක දුන්නොත් එහෙම අර carry out කරන්න අමාරුයි. There are two appeals after the LT gives its decision. Firstly to the Provincial High Court and thereafter to the Supreme Court. The entire process may take a further 3 to 5 years. මේක හින්දා තමයි අර තව ස්ටෙප් එකක් වැඩි කරලා මුදල් දීලා යන්න කිව්වේ. කලින් තිබුණේ නැහනේ මේ ප්‍රොවින්සියල් හයි කෝඩ් විතරක් ගිහිල්ලා යන්නද. දැන් එහෙම නැහැ. මැජිස්ට්‍රේට් ඊට පස්සේ හයි කෝඩ් ඊට පස්සේ කෝට් ඔෆ් අපීල් එහෙම යන්න ඕනේ. ඒ LT නෙමෙයි ආ. අනිත් LT නම් කෙලින්ම ප්‍රොවින්සියල් හයි කෝඩ්. Well, so this is end of the presentation, and now time for you to raise question if you have. Participants online, is it clear? අපු කට ගෙනියන්න කිව්වොත් ඔව් උත්තර දෙන්න. සතයි විකු බොළු වගේද කට්ටිය. Any question or clarification?
clear.
Pereira, is it okay?
Yes, sir.
Okay, right. Someone is there. What about you? Any question? Is it clear? Everything? මේකත් නැත්තම් clear නැත්තම් මන් දන්නේ නැහැ. මට මේ ඊට වැඩිය. So always raise question. Question එක සමහර ඒවා තියෙනවා අපිට තර්ක කරලා උත්තර ගන්න බෑ. පණති දින එක පිළිගන්න වෙනවා. right? ඒක හරිද වැරදිද කියන එක වෙනම කතාවක්. But provisions හරියට දැනගන්න. එහෙම නැතු වුණොත් and you have examination as well. මට පිස්සු ඇදලා multiple questions 40ක් හදන්න කොහොමද කියලා මම කල්පනා. multiple පොඩි දිනා නේද? පොඩි කෑලි වලට කඩලා තමයි දාන්නේ. Don't worry about the examination. Yeah, because the entire module was conducted by me. ආයනන් කරන්නේ නැහැ. කෑලි අවුරුද්දක් කරනවා. ඔය සල්ලන දෙලියක් MCQ වල මේකද 20ක් තිබ්බනම් ඇති. අකුණු 20යි දෙන්නේ කොහොමද? අකුණු 20යි දෙන්නේ බය ඉතින් මේක හදන්න දැන් මම ඔය කලිමුත් වෙන තව තැන්වල කරානේ ඉස්සර කියන්නේ කොමසාරි ජෙනරාල් වෙන්න කලින් කොමසාරි ජෙනරාල් වුණාට පස්සේ රිටයර් වෙනකම් මුකුත් එහෙම කරලා නැහැ. ටිකට් ටික කාලේ. ඒකට මම ওই 40ක් තිබී තැන්වල 20 කරා. මට 20යි දෙන්නේ. අපිට හදන්න බෑ මේ. කියන්නේ එන ඉතින් කෑල්ල පුංචි ඒවා දේවල් ඔක්කොම අහන්න වෙනවා. MCQ වල ගන්න ලේසි කියන්නේ ඔක්කොම කවර් කරන්න වෙනවා. හරිද? හැබැයි මේන් questions 7ක් තියෙනවනේ. 7න් 5ක් ලියන්න ඕන. Conciliation is more important. Conciliation. Conciliation එකෙන් සමහර වෙලාවට කියමුවත් කොහොමත් මෙන්න මෙහෙම හැදෙනවා. collective agreement and collective bargaining වලින් එකක්. collective agreement collective bargaining වලින් එකක්. එකට දාලා දෙකකට දාලා ගමු. ඒ දෙක එකට යන්නේ. ඊළඟට conciliation වලින් එකක්. arbitration වලින් and industrial court එකක්. LT එකක්. හරි. ඔය පොඩි කෑලි අහුලලා කරන් කරලා ඉතුරු ප්‍රශ්න දෙයක්. ඒ කියන්නේ දැන් විශේෂයෙන්ම ඉන්ඩස්ට්‍රියල් ඩිස්පියුට් කියලා අපි මුලින් කතා කරපු එක තිබ්බනේ. ඒකයි එක දෙකක් විතර හැදෙන්නේ. ඒ කියන්නේ benefits of industrial settlement. Problems again, advantages, disadvantages. Over. මොනවද අහන්නේ කියන්නකො මම මේකෙන්. මෙහෙමයි. කොයි වෙලාවකවත් මතක තබා ගන්න හැමෝටම කියන්නේ මට අනතේ වගන්තිය වුණා නැහැ. කරුණු විතරයි ඕන. කරුණු විතරයි ඕන. හරි. definition තියේ collective bargaining කියන්නේ මොකද්ද? collective agreement එකක් කියන්නේ මොකද්ද? industrial dispute එකක් කියන්නේ මොකද්ද? worker කෙනෙක් කියන්නේ කවුද? employee කෙනෙක් කියන්නේ කවුද? මේ definition. හරි. එහෙමම තියෙන්න ඕනේ නෑ. but you have to dispute can any difference between employer or employers ඔය කතන්දරේ employer and the trade union and the workman with regard to employment, unemployment, terms of employment, conditions of employment, termination of employment, reinstatement, employment of a worker. Collective bargaining, collective agreement, and the mechanisms, entire mechanism. Summarize, say for example, summarize the entire mechanism of industrial disputes, settlement of industrial dispute under Industrial Dispute Act. So, රූප සටහන ඔළුවේ තිබ්බාම section දාන්න ඕනේ නැහැ. right පොඩි පැහැදිලි කිරීම ටිකක් චුට්ටක් කරන්න. ඒකේ එහෙම වුණොත් එහෙම ලොකු ප්‍රශ්නයක්. ඒ තනි ප්‍රශ්නයක්. හරි. මේ හැමෝටම ඇහෙන්න කියන්නේ තනි ප්‍රශ්න. ඒකට graphic එක තියෙනවා IDA Act, commissioner යටතේ මොනවද? minister ඊට පස්සේ LT. ඒකට commissioner කරන්නේ මොනවද? කෙටියෙන් කියන්න ඕනේ. ඒව detail එනවා reconciliation වලදී වෙනම ප්‍රශ්නයක් එහෙමයි. ඔය අරකේ එකක්. හරි. ඔළුවට දාගත්තා නම් මේක. මට ඕනේ නෑ මේ technical wording. මොකද we are not producing lawyers. We are fine tuning the knowledge of HR people. HR අයගේ knowledge එක fine tune වැඩ කරන වැඩේ විතරයි. ඒක මේ එහෙමයි. ඔයාලා කෙනෙක් retire කරනකොට, terminate කරනකොට හරි මොනවා හරි කරනකොට section එකක් follow කරන්න ඕන නම් section එක follow කරලා ලිව්වට ප්‍රශ්නයක් නෑ. එතකොට තියාගන්න ඕන නම් දැන් ඕන වෙන්නේ මොකක්ද? මේ විෂය කරුණු ටික ඔළුවට දාගන්න. ඒක which one is the I mean so far you have done completed 3 not completed. ඊට පස්සේ මොකද තියෙන්නේ? agreement, collective agreement ඒව නේද? ඒක තියෙනවා ඊට පස්සේ finish නේ. හැම මොඩියුල් එකේම ප්‍රශ්න 40ක් තියෙනවා MC. So then the participants from online, right? I'm going to wind up if you don't have any question. So thank you very much and have a good day. You can leave now. Oh. So listen to me, right? The assignment would be, right? You will get it next week, but most probably for everybody's benefit, the assignment would be like this, the title. Sri Lanka has very clear and good provisions in relation to settlement of industrial dispute in the private sector, private and sector. Critically evaluate. Critically evaluate. ඒකට ඔයාලා ওই සෙට් එකම කියන්න ඕනේ. මොනවද තියෙන්නේ මේවා කරන්න. ඒවයි තියෙන ඩ්‍රෝබැක්ස් කියන්න ඕනේ. කන්සිලියේෂන් වලට කාල් ගත වෙනවා. මම ඒවා කිව්වා. right? කන්සිලියේෂන් ඇදී සෙටල් කරන්න බලන්න. ඔය ඇදී යනවා. right? ඊට පස්සේ arbitration වලට ගියාම how do we make sure that it's a just an equity, the arbitrator has followed just an equity principle. ඒ වගේ අරුණ තමන්ට critical evaluate කිව්වම you can say whatever you want. right? System එක කියනවා. මෙහෙම තියෙනවා industrial dispute act එකේ section වල මොනවාද තියෙන්නේ මොනවාද there are provisions under agreement settlement can be done, conciliation through conciliation, voluntary arbitration and compulsory arbitration and labor industrial court and labor tribunal, right? What each one is doing. The conciliation, what are the advantages, and critically evaluate. You have to mention the positives and the negatives. Okay, that would be the වචන 5000ක් තියෙන්නේ. 1500යි. 1500 කියන පිටු පහයි. පාටක් අඩිය අපරක් විතර. මොකද type නම් one page එක 350 word එක. එක පිටුවක times new roman 12 නේ යන්නේ. 12 ගියාම පිටුවකට වචන 350. හරි 350 කියන්නේ maximum 5යි. පහකුත් අඩුයි. හතරක් විතර. Okay, well, then
revision class කරනකොට තියෙනවා.
revision එකක් තියෙනවා. ඉතින් ඔය revision එකේ ඔය ටික තමයි කියන්න තියෙන්නේ.
Zoom එකේ.
ඔව්. මෙහෙමයි. නෝ සමහර වෙලාවට මට හිතෙනවා මේවා තියෙන්න ඕනේ. Okay, I'm winding up, right? You can leave. Good day and